No, you wait. Both of you.
Therefore, listing lordship for admission matter lordship. The materiality lordship, family pension lordship.
Huh?
Family pension lordship.
Give a date.
22.
Please, your lordship, I beg to mention item number 47, lordship. In this case, we have filed a affidavit in reply yesterday, but it is not that matter may be list on Friday, lordship.
No, not Friday, tomorrow.
Any date may be given.
You have filed affidavit in
Reply yesterday.
yesterday.
Evening.
Right. Miss, what is your name?
S.A. Khalifa.
S.A. Khalifa.
Khalifa.
Khalifa, appearing on behalf of
MSK Devi.
Mrs. K. Davis. That means that affidavit in reply has been filed yesterday. Accordingly, leave this matter after a week.
Please, your lordship. Also, I pray for listing of a repetition, my lord. Matter relates to completion and appointment, my lord. In the next week, my lord, any Wednesday or Friday. A similar prayer regarding a repetition for admission, my lord. I'm obliged.
I beg to mention item number 2, lordship. I am on behalf of M. Islam, lordship. He is out of registration, lordship. So kindly adjourn the case, lordship. Only for today, lordship.
Okay, and the prayer for adjournment made on behalf of the petitioners council is the matter in the next week.
Okay.
Just right to stop the matter relates to grant of family pension between the petitioner and respondent number 7, who are the wife and mother of the deceased respective. In this matter, in this case, the petitioner and her family had been arrested due to the death of her husband.
May I please, Lordship, in this case, petitioner was suspended, Lordship, on 18/5/2023 with effect from
18/5/23.
Lordship.
With effect from?
18 May of 2023.
Okay, 18 May 23. Then with effect from 18/5.
13/5, with effect from 13/5.
With effect from 13/5.
13/5,
Order is of 18/5.
Lordship. More than
So,
3 months, Lordship.
We have already initiated disciplinary proceeding, my lord.
no, but then
No, till date, we have not received any.
This is the so-called document. In on last opinion also, I have produced this, my lord.
We have not received any so-called.
Then
oh, maybe.
he informed about his enlargement on bail on 11/8, my lord.
Huh?
He informed about the bail on 11/8/2023, my lord.
But your review has to take place within 3 months.
Yes, but from 11/8 to it should be from
No,
11
no,
from the date of knowledge, my lord.
No.
This has been held by
date
this
of whose knowledge?
knowledge of the department, my lord.
Who do you think suspended him? Did he suspend himself?
No, my lord. Regarding my lord, his release on bail, that he has to inform the department, my lord.
That is a different issue.
So he informed only on 11/8, my lord.
Maybe. But then
So
you
from 11/8, 3 months, my lord.
no, show me the law.
Yes, my lord.
Then, in that case also, Lordship, 90 days have passed, Lordship.
Huh?
In that case, Lordship, from 11/8, Lordship, 90 days have passed, Lordship.
Where is the show cause notice? That is on 12/10/23.
So, notice, Lordship, is not served What? What?
Yes, where? Which?
Paragraph 20 and 21, my lord. Relevant portion is 21, my lord.
When is this Rakibuddin judgment? I have to read this. I don't know.
In Rakibuddin's case, Lordship, Ajay Kumar, in Rakibuddin's, I have given the Rakibuddin.
Yes, yes, para. Which para are you talking about?
I have,
Para, I don't have time for that.
Paragraph 15, my lord.
Yes, where is the suspension order? Page,
Page Lordship 21.
we see this, let us see this issue again. Just let me see this, let me read it properly. Okay, right. The petitioner's case is that he had been suspended. He had been placed under suspension by an order dated 18/5/23 with effect from 13/5/23. And as there was no review of for the extension of the suspension order within 3 months, as required in the judgment of the Supreme Court in Ajay Kumar Chaudhary versus Union of India, 2015, 7 SCC 291, and Rakibuddin Ahmed versus State of Assam and others, 2022 GLR 621. The petitioner's suspension would have to be set aside and reinstated. Full stop. On the other hand, Mr. NJ Khatanier submits that show cause notice has been issued to the petitioner on
10/10/2023, my lord.
10/10/2020. Issued on 12/10/2020.
12/10.
Full stop. Besides the above, the petitioner was released on bail in the criminal case on
He released on bail, my lord, wide order. On 19/6/2023.
19/6/2023. And as the petitioner had not informed, and as the petitioner informed the authorities
Only on 11/8.
only on 11/8/2023 that he had been released on bail. The period of 90 days for review of the extension of the suspension order would have to be counted from 11/8/2023. In support of his submission, he has relied upon the judgment dated 17, the judgment and order dated 17/2/2023, passed in WPC 455/2020. This is a matter on
Lordship, from 11/8 also, Lordship, 90 days have already been elapsed.
how? Because they said notice has been issued to you on show cause notice has been issued to you on 12/10. So if it's 11/8 to 12/10, it's only 2 months. It's not 90 days, it's 60 days.
No, from the date of 11/8, from the date of my actually the second intimation, Lordship. 11/8 is my second intimation.
Huh? When is
11
your first intimation?
Lordship, 30 June, Lordship page, annexary page 26, Lordship.
But they have not received, Lordship, so the second intimation was given.
Page 26, Lordship.
When did you write this letter? 36.
36, Lordship. There is no acknowledgement on that letter, my lord. In fact,
But
yes,
there is no, in the same vein, there is no acknowledgement in a show cause notice also.
Lords, we have served a copy. In fact, on 11/8, it is in vernacular. I have the copy, my lord.
What?
On 11/8, he informed the department that letter I have, my lord. It is in vernacular, my lord. And we
It
have
has been
received it.
submitted through the headmaster also.
But where is the acknowledgement with regard to your show cause notice?
That I will produce, my lord.
Mr. N.J. Khatane shall produce the records to show that show cause notice was issued to the petitioner on 12/10/2023. List the matter on Monday. List the matter on Monday.
Obliged.
Let me see this judgment.
Please, Lord, my lord. My lord, petitioner was arrested in connection with a criminal case, my lord. Thereafter, I will put under suspension, my lord.
When?
My lord, I was arrested on 24/3/2000,
24/3/23.
my lord.
And
That
placed
is
under
Annexure
suspension.
1, my lord.
You placed under suspension when?
My lord, 24/3/2003, my lord.
You were arrested and
My lord,
suspended
on
same
that
day.
day, my lord. The Annexure 1,
Quite order dated.
by order dated 24/3/2023, my lord. The Annexure 1.
Then what is your case?
My lord, after that, my lord, I have been released. Accordingly, I have made a representation before the authority to release my substances allowance. And thereafter, my lord, I have made a representation to reinstate me pending departmental proceeding, my lord. Then thereafter, after my representation, they have issued a show cause notice to me, my lord. This Annexure 5, page 29.
So cause notice dated 7/9/23.
My lord. Accordingly, I have replied on, my lord. I filed my reply, my lord. 25, my lord. 25
25?
September.
9.
9, my lord.
So what is your prayer?
Yeah, my lord, because during the pendency, they have not reviewed the order, my lord. Despite my representative 3 months has already expired, my lord. They have not taken any decision to review, my lord. The continuation of the suspension order. Neither they have released the suspension allowance, my lord.
What is your prayer?
To say they say the impugned suspension order, my lord. For
Yes.
keeping-
Your lordship, just been informed telephonically that subsistence allowance has been released. So I'll get that order, but in the meantime, your lordship, disciplinary proceedings have started as we have annexed that particular show cause notice.
No, but his case is that there was no review of the for extension of the suspension order.
Your lordship, between that 90 days period itself, that review, that disciplinary proceedings had commenced.
No, not according to the thing he's given. He said
Your lordship,
show cause notice was issued only on 7th September.
that would run
You
from
are
the date of,
suspended.
from the date of intimation, not from date of suspension. The very recent judgment of the court bench of this honorable court, Rafid Ali judgment. A fourth principle was actually Rafid Ali, 455 of 2023. And fourth principle was actually enunciated in that particular judgment. That 90 days period would run from the date of intimation. Now here he had intimated only on
On 5/8.
5/8/2023.
Even then today, my lord, 3 months gone.
No, but then he said that you made a reply on 25/9.
29. So within that 90 days period.
So before 2 months had elapsed, you had submitted.
My lord, drawing and departmental procedure and review of the order is different. They have to show the review of the order, my lord.
Huh?
That issuing show cause notice, my lord, and the review of the order is different, my lord. They have to show.
Mr. Counsel, when were you released on bail?
My lord, I was released on bail, my lord, 6/5/2023, my lord.
6/5/23.
My lord. Thereafter,
When did you intimate your release on bail?
21/6/2003, my lord.
21/6/23.
My lord.
Then 21/6. So according to this Rafid Ali's case, you were supposed to your 90 days would start from 21/6.
No, not from 21/6, your lordship. 21/6, he has annexed at page number 24. Nowhere in that representation he has stated I have been released on bail. He only stated on page number 27 on 5/8/2023 that he was released on so and so date.
Yes, so this, it was, information was given to you when? No, so 90 days will be counted from which date?
From the date of intimation.
That is what, so this is the
5/8,
information.
my lord, that will be
No,
from
no.
5/8.
5/8.
Correct,
Page
for
number
5/8,
27.
Huh?
Page number 27.
27.
27.
What about this 24?
24th, Your Lordship, there is no mention as such that he was released on bail and I am.
Yes, para 2, in this regard.
In this regard, I would like to inform you, it has been almost 3 months that I have been released on bail by this officer.
Correct.
But when, Your Lordship, when?
How does it matter? But on this date, the date of the letter, you are informed.
This is, I don't know when it is dated, of course, because it is not stated there then. It's 21/6/2023.
What
So
is
even if-
what is the date of this page 24?
It's vernacular version.
That is at page 26.
21/6/2023.
So you are informed, he informed you on
Even
21.
if we take,
21/6, my
even
lord.
if we take it at 21/3/6,
That's it.
then also
Within
90 days
90 days.
period from 21/6. This particular show cause notice was issued on 7/9/2023. Because that 90 days period would end again on 21/9/2023. Your Lordship. 90 days period from the date of intimation. So within those 90 days period, the show cause notice was issued and he filed a written statement to that particular show cause notice. And now para 22 of the Ajay Chaudhary judgment will apply.
Now, which,
Para 22 of the Ajay Kumar
what
Chaudhary.
does it say?
It says that if suppose otherwise, if disciplinary proceedings are commenced, he may challenge the suspension order on any other ground, but not on this ground of review not being undertaken.
If it has already commenced.
If it has already.
And if he had not made a challenge earlier.
Yes, and if I may read out that para 22 for your lordship's consideration. So far as the facts of the present case are concerned, the appellant has now been served with a charge sheet, and therefore these directions may not be relevant to him any longer. These directions may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continued suspension in any manner known to law, and this action of the respondents will be subject to judicially. So,
Anyway, let me read the judgment of the coordinate bench.
My lord,
Otherwise, as per the coordinate bench judgment, you have got no case.
my lord.
Let me see if I agree with it. Because I've seen it just now only.
My lord. It might be another day, my lord.
Yes. Right, third, Mr. M. Saranya, learned counsel for the petitioner who submits that the petitioner was placed under suspension on 24/3/23 as he was arrested in a criminal case. Full stop. The petitioner was released on bail on 6/5/23 and he intimated the authorities with regard to his release on bail on 21/6/23. That show cause notice was issued to the petition on 7/9/23. And the petitioner made a reply to the same on 25/9/23. The petitioner's counsel submits that the petitioner should be released on bail as the review of the suspension order, the review for extension of the suspension order had not been made within 90 days in terms of the judgment of the apex court in Ajay Kumar Chaudhary versus Union of India, 2015, 7290. Full stop. On the other hand, Mr. D. Bora, learned counsel for the respondent, submits that in terms of the judgment and order dated 17/2/23, passed in WPC 455/2023, the period of 90 days for review of the extension of the suspension order would have to be counted from 21/6/23, that is the date the authorities were informed of the release of the petition on bail. list this matter on Monday.
Hello.
Monday.
This is the last order. That is 29/9.
What is the case, basically?
I'll just tell you, explain to you.
Basically, they need to be regular. When they are appointed on a non-sanctioned post, ultimately it had to be, that sanction has to be taken. The BTC has written to the education department.
They have been appointed against non-sanctioned posts.
Non-sanctioned post. Now.
So what
ultimately-
sanction has to be taken? If it's a non-sanctioned post, it's a non-sanctioned post. Where's the question of giving sanction to a non-sanctioned post?
Thereafter, an appeal that petition was dismissed, appeal was preferred. And that
No, just a minute. They were appointed against non-sanctioned posts. Correct, when?
now make my note.
May I explain lots of petition?
Yes, yes.
I will explain. What my friend is saying may not be correct. Initially, we were appointed as assistant teachers,
When?
1999.
Yeah,
We received our salary, of course, there's a patch, so the exact date may change, but in till 2006, 2007, the people received their salaries. I'm appearing for 5 writ petitioners. 5 writ petitions, my colleagues are appearing for the others. Now, after in 2006-7 period, we were terminated.
terminated, by order dated?
Not sure the order is.
One order or
There
various
are
orders?
separate orders, separate orders.
Issued when? In 1 year or different years?
2006-7 period. 6-7.
Terminated 2006, 2007.
Yes,
Okay.
lordships.
On what ground?
Illegal appointments.
They just said it illegal appointments.
Yes. We challenged that,
By way of,
a writ petition.
there were various writ petitions or
There were
one?
various writ petitions, so
And
the
wha-
people
wha-
came to this court,
And they were tagged together or what?
they were tagged together. and
Leading
fi-
case being?
The lead. I'll provide the exact number, lordship, but what the learned.
I don't want the leading case number. No, no, let us not, because I don't want, let us go step by step.
Yes, yes, I bow down to that, lordship. Yeah, but you come to the, in fact, lordship, I'm just give me a moment, my colleague is. Now, what happened, the learned single judge remanded the matters back
To whom? To
to
the,
the authority, to saying
by order dated?
uh, that is not there in the annexure, lordship.
That is not done the next year.
No, because that case is not here. That is over.
Maybe, but then when you want me to understand the history of your case,
Yeah, that,
shouldn't you give me the exact particulars?
I bow down to that, lordship, but
You are bowing down to that, but you're not providing me the details.
I'm,
Your bowing will not help.
I'm sorry, lordship.
Ah.
2152 is the writ petition,
2152 of
2009.
2009.
Yes.
Disposed of?
In fact, lordship, at page 78, it is extracted in the division bench order, which is now for lordship.
Unfortunately, this is not the division bench.
No, what happened was that.
Where is it? Where is the division bench order?
That is before in the paper book.
Where? Which paper book?
5741 of 2017. Is lordship.
5741. Give me 5741.
Item number 18.
Item number 18, that is. Okay.
This is Chakrapani Das.
Which page?
Page 78, Lordships. Is the order on the basis of which this proceeding started.
Just a minute. Where is the order of the single judge remanding the case back?
No, that order is not there, but the reference of what the single judge did is extracted in the order.
Where is
That is
that?
what I'm saying. If the Lordship says it is the case of the appellants, that the appellants were appointed in the year 1999 and earlier thereto, the appointments of the said teachers came to be terminated as being illegal, and that the appointment orders issued by the District Elementary Education Officer, Block Elementary Education Officer, Nalbari District, were illegal. Therefore, the termination orders were issued by the Director of Education, PTC. This court in WPC 2152-2009 batch had found the termination orders are illegal and remanded the matter to follow the principles of natural justice. The Director of the Education redid the exercise and again terminated for the second time, giving the same reason. Agreed by the said order, the appellants have filed this. Then what happened in the second round? I may place the next paragraph also.
Just a minute.
That number one.
Yes.
The learned single judge has found the orders of appointment as being issued illegally and that the order of termination is legal, hence dismiss the writ petition. Agreed by the said order, the appellants have filed his appeals. Now, this is the order that disposed of the appeal, which have now given rise to these proceedings. Now, may I place this order? What does the order say? Heard the appellants and the respondents. The policy decision taken by the Borough Territorial Council, BTC, is received.
No, where?
Same page. This is the order.
Heard. Where do you read heard?
First paragraph. First paragraph.
Yes.
Yes. The policy decision taken by the Borough Territorial Council is received on record. The appellants were teachers appointed and working in various MV schools in the Borough Territorial District jurisdiction area. The next paragraph I've read, Lordships. Thereafter also I've read. Now please come to the last paragraph of the page. It is submitted by the council for the appellants that the appellant herein were receiving salaries up to 17/10/2006, and thereafter a termination was
So it's up to 2006, not
Yes,
7.
No, I said 6, 2006, 7. There were 45 petitions, so it could be here and there. The PTC as well as the government of Assam took a decision to regularize all those teachers who are in service and are regularly receiving salaries up to 17/10/2006. In the first phase, it is submitted that 221 teachers have been found to be eligible for regularization as per the above norm. It is the contention of the appellants that the appellants are also similarly placed and they should also receive the similar treatment of law. The council appearing for the PTC submits that the policy decision is taken and the persons receiving regular salaries from the month of March 2006 would be regularized and the implementation of the policy is in process. The government of Assam has also agreed to the said policy. In view of the above submission, the writ appeals are disposed of with the direction to the respondents to effect regularization as per the policy decision of all those eligible teachers who were regularly receiving salaries up to 17/10/2006. Needless to say that if any of the appellants is aggrieved in the decision making with regard to the tenure of the service rendered and receipt of salaries, they can approach this court by separate petitions. Now, having passed this order, the next thing that is relevant is the order dated on 22nd September 2015.
Page.
Page 82.
So basically, we are interested in this writ petition. Only.
Yes. Now what happens?
So this other writ petition can go away.
Yeah. So this writ petition now now please see page 82. After this order, what happens?
Page 82.
Yes. 22nd September 2015 order.
Yes.
In pursuance of Boroland Territorial Executive Council Executive Meeting Resolution number 4.1 dated 27/4/2015 and resolution number 4 in the minutes of the departmental meeting of Education Department held on 26 June 2015 respectively, the Boroland Territorial Council is pleased to withdraw the termination order by so and so dated 6/11/2008 against so and so in terms of directory elementary education order so and so with prospective effect. So now, this is a sample order. Such orders can be passed against.
So termination was done between 2006 and 2008, not
Abs-
7.
Yes, yes.
So you said 2007,
2006, 7. There are various dates. There are-
8, oh, 8 also. This 8, what you have read just now is 8.
Yes. And
Please be careful with your facts.
so actually I am representing 5 petitions.
Whatever, but when you were reading just now, I have not seen 2006 or 2007. I have seen the year 2008.
2008.
Then why did you make a submission that termination was of 2006 and 7? It is a termination of 2008.
I'm sorry, Lordship, for that. So therefore, what happened? Such orders can be passed with respect to all the people. Similar withdrawal of termination, which was followed by order dated page 83. And then please come straight to Lordship, page
Just a
116.
minute.
116.
But
One-
with the withdrawal of termination orders, they are made with the effect from
Prospective effect. That is what the language they
from
use.
22/9/2015.
Yes.
Prospective effect. So
Thereafter is followed our regularization. Which order is that? Page 114.
1
That's a typed copy, 114.
114 is the regularization order.
Yes, may I just place it?
Yes.
1 October 2015. In pursuance of Guwahati High Court, Honorable Guwahati High Court judgment on order dated 6/2/2015, that is the order we read. Passed in writ appeal 182/2013, passed in event of miss case number 183 of 2013, filed by the PTC and consequent upon PTC Executive Council meeting resolution number 4.1 dated 27/4/2015 and departmental meeting of Education Department resolution number 4 dated 26/6/2015 respectively, and in consonance with the approval received from the PTC by letter dated so and so dated 30th September 2015, and on being termination wide withdrawn by the PTC by order dated so and so dated 28th September 2015, Chakrapani Das, who was terminated from service by order dated so and so dated now issued from this end, is hereby withdrawn, and his services is regularized, reinstated as assistant teacher in number 2 Subhansiri LP school in the scale of pay of so and so plus other allowances as admissible under existing rules. The regularization of the services of the individual teacher shall be subject to the following terms and conditions. Then it says this regulation also shall come into force with prospective effect and the other things, the following. Now the issue before your lordships is, despite this regularization order, we are not being paid salaries.
Okay, so it's only with regard to salary.
No, principally. But otherwise, if you see, we have got other reliefs also. In this petition, lordship, if you kindly see the reliefs that we have sought for.
Okay, one is non-payment of salary.
Yes.
From
15, from the date of our regularization. And it is not across the board. Some people are getting.
What do you mean? What do you mean some people are there?
Yes, we have given a chart on the last occasion. Some people are being paid, some are not being paid. That is
Okay, some people. How many people are being paid?
yes, that order is already there. Lordship will kindly see. This order is already there before your lordships. Kindly see the order dated 25/7/2023. Where the learned judge has extracted every writ petition, how many are paying and how many are not being paid.
25/7.
2023. Order
Yes.
by Lordship Patel.
Yes, where does it say?
Yes. This is that he has extracted everything. I am now talking about the petition I am appearing at serial 10. Writ petition 3272 out of 45 petitions, just 27 are receiving current salaries and 18 petitioners did not receive their current salary.
No, Mr. Kaushal, just give me the numbers. I cannot go calculating now.
Total to people. As of now, I think that's 421.
Paragraph number 40 will make it clear, my lord.
40?
positive of that particular order, madam. 892 are receiving it.
And 421 are
421 of it.
still not getting.
892 receiving salary,
And 421 are still not getting.
Among the petitioners that are
421
Are
not
yet
get,
to get.
not get it. From 1/10/2015. Now that is one aspect.
That is one aspect.
That so you have to get.
We have to get.
That you
And
have to
I'll
get.
show you
There is
also.
no doubt about it, I think. Mr. Bora, is there any doubt with regard to the fact that the persons who have not been paid their salary have to get it?
yes, that
That-
for that, my lord.
No, I'm not talking about for that or not that.
They,
Are they entitled to get their
they are
salary
entitled to get,
from the date of regularization?
but they are entitled. I am saying from the state of the BTC, my lord, they are entitled to it. But our finance is not a authorized subject of the BTC.
That's a
So,
different
government
thing. That's a different
take it
thing.
From the
That's a
state.
different thing. That's a different issue. Okay, that issue that we will cross that bridge when we come to that. Right now, I just want to know whether they are entitled or not. According to you, they are entitled. That's enough. Yes.
And the court records our entitlement, the previous orders, time and again.
Anyway,
Yeah.
then next.
The second relief that we are seeking is that we are aggrieved by the use of the expression prospective effect. We are saying please relate it back. That is the issue Lordship will have to adjudicate. They are doing everything by prospective effect. Termination by prospective effect, regularization with prospective effect. Why not our previous, why are you not counting our previous job?
Because your previous job was illegal.
No.
Your appointment was illegal.
Ultimately, it has been regularized. So whether.
Maybe, but the illegal, how can the
so
illegal
therefore,
portion be
that is
regularized?
one aspect where we have to,
That is you can give your submissions on that count.
yes, address.
Now
the
let,
Lordship.
let us go back.
So
In that
today-
case,
Today, so therefore, today, the issue before your lordship is at least in the interim, whether these people should be paid or not. There's the human issue.
that is one aspect. I'm not going to do things in bits and pieces.
Okay.
Either we dispose of the entire thing or I'm adjourning it, whatever. You want me to dispose of the entire thing, we'll dispose. And you cannot just,
May kindly see the last order. I was supposed to place the status. One proposal has now been submitted by the BTC through the education department to the finance SIU department. And it is under examination as per the latest instruction that I have got. So I pray my lordship will take up this matter after 2 weeks or 3 weeks.
for why?
Well, on that, my lord, because my lord, the entire, so far as the selection is concerned, in 2000.
No, you see, right now, I think we are not there's no dispute with regard to the fact that they have got to be paid their salary from the date of regularization. That is not disputed, I think, by you also.
That part, my lord,
That
yes.
part. Now, the only issue that has to be considered is whether they should be given their salary from the date they were originally appointed or not.
Here, my
So let us look at that issue. That's all. That's the end of the matter. Since I've heard this much. Yes. Tell me.
So in that case, lordship would then consider keeping it on next Wednesday.
No. I'm hearing it now.
Because
What is this?
today, I'm being very candid, lordship. So
Ah.
we're on the focusing more on at least getting some interim relief of.
Mr. Counsel, you know that this is, I'm quite sure, not a few pennies here and there. I'm quite sure it might run into crores. And money is something that doesn't grow on trees. So it's
All
not
I'm
there
saying
for
is,
the, it'll take some time. It'll take some time for the money to come. But for that, orders will have to be passed. And probably contempt case might have to be filed also. I'm being realistic.
In fact,
So that is only one aspect of the matter. Why should I hear only a part of your argument
well,
when I can hear all the? You can take it up now.
So
No,
therefore,
you tell me.
because I'm telling you, lordship, I'm in some difficulty. So if lordship can keep it on next Wednesday or Thursday, whenever it's done, whenever it is. Because I was given the brief only yesterday, lordship.
You gave the brief yesterday.
Yes, lordship. I'm being very candid and very.
Why didn't you
forthright
tell
so far.
me this in the beginning?
No, because we were only focusing on whether they are complying with the order of payment. So let it keep it on next Wednesday, Thursday, whenever it's convenient for your lordship. We'll come and address your lordship on these aspects. Because we are clear about. it. But I believe affidavit filed with them. They have not even filed an affidavit still now by the way.
How does it matter?
So therefore, I'm just pointing it.
How does it matter? The facts are quite clear. Everything is here in your paper book.
Absolutely. Anything, whenever Lord's convenient for Lordships, next Wednesday, Thursday. Thursday, Lordship.
Let it be on 29th.
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 No, not 29th.
Calendar conflict.
Let it be next week or
Let it be next.
29th. 29th. Huh? 29th Tuesday.
Or 28th.
The bench is available. 23rd. Any day when I continue.
29th is Wednesday.
29th Wednesday.
29th is Wednesday.
28th.
28th, there's a program in Delhi which I have to attend.
I mean, in December, first week of December.
Huh?
December.
No, I will be. There is no doubt about it.
Let it be convenient, let it be the.
But of course, if you want excuses, there are enough excuses. Hornbill is there.
That is Hornbill Festival.
Let it be in the first week of December.
Okay, right. Heard, Mr.
Manish Goswami.
Manish Goswami, learned counsel for the petitioner. The basic case of the petitioner is that they have not been paid their salary from the basic case of the petitioner is on two counts. Firstly, that they have not been paid their salary from 1/10/2015, comma, that is the date from which their services were regularized. Bracket page 114 in WPC number 5741/2017. Full stop. Secondly, that the withdrawal of the termination orders while various orders issued by the authorities and their regularization order has stated that their regularization and withdrawal of termination orders would be with prospective effect. They are aggrieved by the use of the word prospective effect. That the regularization order, bracket page 114. Page 114 bracket. Full stop. The genesis of the case, comma, as stated by the counsel for the petitioner, is reflected in the order dated 6/2/2015, passed by the division bench of this court. In a batch of writ petitions, a batch of writ appeals, comma, the lead case being WA 182/2013. Bracket. No, sorry, no. Bracket page 31 to 79. Bracket close, huh? Full stop. Next para. On the perusal of para 40 of the order dated 25/7/2023 passed by this court in WPC 5281 of 2016, It is seen that out of 1317 writ petitioners, 892 are receiving their salaries, while 421 have not received their salary. Next para. On the prayer of the petitioners' council for listing the matter in the first week of December 2023, which is not objected to by Mr. S. Bora and Mr. B. Gogoi. Learned counsel for the respondents. List the matter on
December, subject to lordship's convenience.
fifth, no?
Very good, for lordships.
May it please your lordship.
Lordship, before my learned can start, my lord, it's a matter pertaining to non-payment of period salary, my lord. I have received one instruction.
Item,
Article 46.
yes.
Lordship, I have received an instruction on last October. It's under process. I will get the up-to-date instruction, lordship.
Okay, Miss MD Bora, Learned Standing Council, Welfare, Minorities and Development Department submits that.
I'll get the updated instruction.
She'll get the updated instructions with regard to
Payment of the area salary.
payment of the area salary and pension
Lordship,
and pension / service benefits. By which date?
weekend,
Huh?
next week, money.
By today's what date? By 30th. List the matter of 30th.
Lordship, deeply obliged, my lord.
May it please your lordship. Well, in this case, there is a background to the case. There are two categories of cases. Well, this matter relates to the Bhagwan Pater matter where the reservation promotion. We won the single bench, we won it, and in the division bench, the upheld our order. And this is the order. The main sum and substance of the judgment is that we were denied the benefit of merit, and the Bhagwan Pater struck it down on the violation of R.K. Sabharwal. IV Guha in the appeal, they took the same ground that was rejected, and in fact, the division bench clearly said that promotion will be cadre-wise, because our entire grievance was in violation of the service rule. They made it into a new concept of date of entry into service. So this judgment,
This order,
yes, this assailed the order of Bhagwan Pater,
assailed the order passed by which single judge?
by Honorable Justice A.D. Chaudhary.
That has been upheld.
Yes. And
No,
in
no,
fact,
my lord.
today there are two categories of persons.
I'm sorry to intervene, my lord. My learned friend would like to say that the A.D. Chaudhary judgment has been upheld. I'll say, my lord, it has not been upheld. So
Well,
therefore, my lord, this matter has to be traced out first.
My lord, this
One second, please, sorry. Why I'm saying so, my lord? Our contention before the learned single judge was that in view of two subsequent notification of Government of Assam, that is, my lord, one of 2014 and one is of.
Why isn't this issue? Why isn't that trashed out in the division bench?
Look, we just traced out, my
Well,
lord.
it
I'll
was-
satisfy your lordship.
Well, if I may, because this is my case, I'll have to make my submission. Well, they'll be making their submission when the turn comes. Well, I want to.
Today, what is going to happen?
Today, two things is going to happen. The court will decide. Okay. Item number 48 to item number 42. These are matters which relate to clause 4
which has been struck down, and there is
Clause
no
four of, clause four of.
clause 4 of
No,
an OM of 16.
Huh?
Clause 4 of an OM of 16, which debarred us the benefit of merit. That is
48 to
48 to 52.
52. Huh.
And what happened subsequently to it, the Assam government overturned the judgment of the single judge, and they brought about a new OM where I had challenged from Langta item 53 to 59 or 60. Because on that, my learned friend will definitely have their objection that the detailed hearing is required. But insofar as 48 to 52, the fact that the division bench has clearly reiterated Supreme Court's order that it will be cadre-wise, what more hearing is required? Because now the division bench's order has to be complied with, and consequential orders giving us the benefit, because they got the benefit without the cadre. The court says cadre-wise. So I get the benefit. So your lordship will dispose it of in terms of the division bench cadre-wise. And the judgment is very specific. Supreme Court's order is in
No,
my favor.
where does it say?
Yes.
Cadre-wise?
Yes, yes.
48 to 52.
Well, if your the factual matrix of item 48, 1252 is the same. Once I explain your lordship item 48, the rest will follow. The lordship will take up the 48. 1.3700. Yes, lordship will take up 3094. Hello, the petitioner.
No, what is your prayer in this 3094?
The prayer was that we were downgraded because the benefit of the rules were not given to us. The cadre was not taken into consideration. Date of entry into service was taken, which was absolutely unheard of. So there we sought that these officers who got a march over us could not have been given, and we could prove it in the Bhagwan Pater's case. The matter went up before the division bench. The division bench clearly said that the Supreme Court's order on Journal Singh 2, paragraph 45 to 46 is very clear. It has to be cadre-wise, not group-wise. What they did, they took the entry into service. It is unheard of. I entered about 30 years back because they wanted to bring in the catch-up principle. That was the mischief the Assam government did. That was done. Till today, the personnel department has not cared to follow the order of the single judge and the division bench. And then they say, since you have challenged the Langtasa's case, item 53, we will do it. We will not follow the division bench. Well, there has to be, lordship will have to take it. They don't enjoy sovereign immunity. There's a judicial process, the rule of law. So what especially the main culprit I will say is the personnel department. They flout. They say will not follow any division bench order till you get it struck, the subsequent case.
I think I'll have to read the judgment.
Yes, yes. But only one thing. There is on the consent of the parties on the last occasion, this matter, seeing the urgency of the case, because the officers of the general and the reserve are stuck in all the 60 departments of the government of Assam. And the government of Assam has carefully ignored the division bench's order. Your lordship, as regards the first case, your lordship can fix it up on Tuesday next. Because your lordship, the first part I need, at least that prayer can be there. Because what has happened?
Which first case?
The first part, because there are two categories.
48 to 52.
48 to 52. And the next case, as regards definitely the parties are there, a detailed hearing is required. Because what has happened now, one thing I like to bring to your notice, the government of Assam, after I have approached the court in 2021, has given 2-3 promotions. I am going down. And they are taking the plea, we will not follow in neither the single judge or the division bench. You get an order of the 2023 new notification. But the Supreme Court in the Patwardhan's case has clearly said that the earlier, the OM, which is brought in terms of the executive powers of the state under Article 162, cannot be given retrospective effect. In fact, there is an order of the single judge also. So, insofar as the 16 OM, it's a conclusive thing that the division bench order covers that area. And the state of Assam government has never went on appeal, neither have the parties gone on appeal. So, I want that at least 48 to 52 orders may be given. That prayer, legitimate prayer, I can always ask. And in the meantime, I have brought in certain miscases on one ground that till the matter is decided finally, because your lordship, this is the last round, and I'm confident because seeing the two forums, they will again affect promotion. There, I want that they will not affect any promotion till the matter is decided. Because they take up the plea, you get an order from the court, we will then follow. Because even after the judgment of the division bench, propriety demanded that the Assam government could have complied with. They don't comply. And the law is lordship. Once your lordship goes to the judge, it's a very categorical statement. Supreme Court has taken up the issue that it will be cadre-wise. Because if it's not cadre-wise, how can it will lead to absurdity because they want the date of entry into the service. And in fact, the Supreme Court is also examining all the matters in India.
Date of entry would be to your favor.
No, date of entry into the cadre will be by favor because I will favor because the rules favor me. The rules are very specific. Date of entry into the cadre. They bringing a redundant catch-up principle and then they say that date of entry into service. Well, after 30 years of going to service, because we get accelerated promotion, we go up. They want to obviate that. That is this case. In fact, lordship knows about this case. 60, the first case I did it before lordship.
No, I don't remember. I've been dealing in other.
But at least we remember the petitioner and the respondents.
You must be breathing this case in and out every day.
Yes, because I had to breathe in because the government was not on my side.
Sleeping, breathing, eating. But for us, I mean, I was in the criminal side for some time and the other thing. So I completely forgot about it.
Lordship, Lordship will remember. We lawyers will remember our case, but lordship will have to deal with so many. So I say that item 48 to 52, lordship, consequential orders in terms of division, where that I can legitimately ask. And as regards that during this process, I want that till the Langthasa's case is not decided and they won't go with promotion. They are going for the third time. At least the petitioners want some justice from the court. Their logic is that.
What is Langthasa right now? What is he? What
he is now additional superintendent engineer. He was also denied that benefit. Same thing. Everyone moves up. Well, what has happened? We get accelerated promotion and we move up the ladder. This OM of 16 created the first hassle for us, which denied the benefit of merit. Once the merit was denied, we had to approach this court. And from 2016, we had to fight our way till 2023, IV Guhai, we win our case. And the government of Assam did not take a neutral stand, especially the personnel department. They say, since we have brought in a new OM, we will not comply with division bench order of any court. They are not complying, resulting in oblivious of the fact that the Assam government, well, our main grievance is against the state of Assam. I have no grievance against the private respondents. The grievance is the Assam government. The Supreme Court has said that you have to be a neutral umpire in service matters. They took the side. Obvious which side they say, I need not say. As a result, what has happened? They are now flouting the Supreme Court's order. And resulting in all officers getting retired. Many officers have lost their legitimate rights because I have come, I will vindicate from my case that my case hinges on the violation of the rules, nothing more. So at least I want that item 38, 48 to 52, the lordship will fix on Tuesday for necessary orders in terms of the division bench. If they have any grievance, they come here or go to the Supreme Court, but at least I have to have the fruits of the judgment. And as regards the other, a short date may be given, Malan. And I have filed 4 applications.
No, if they're not complying with the order, then why don't you have
if the contempt goes, they also know they have the ingenuity. They will say that notice has gone. You wait for the judgment of Langthasa. That's the difficulty. The contempt also will go in its own speed. So that's the reason I could not file. Because they'll take up this plea. Once notices go, they'll say that.
Once an issue has been decided by the division bench, what is the role of the single bench?
Malan?
If the division bench has decided in your favor, in terms of the law interpreted by the single bench, what is my role?
Your lordship's role is that since now
I'll be just reiterating what has already been stated.
During the time when this argument was made, the other side took the plea that we have filed an appeal. Now the appeal is over. Can I not ask for an implementation of the division bench's order? That's the thing I want.
No, but if you're going to ask for implementation of the
Yes.
division bench order,
Yes.
why don't you go to the division bench for that?
Well,
Why don't you tell the division bench this is not being implemented?
why will I go to the division bench where the matters are pending here? The pending matters were kept in by the single bench on the ground that propriety demanded that the division bench take a decision. Now they have taken a decision, can I not ask for it? That's it, simple.
So these issues were
These
not,
issues-
these cases were not considered by them.
No, absolutely not. That's, and in fact, these cases there is no retrospectivity in an OM. It's not a rule under 309, it's an executive instruction. So the 16 OM is dead, the clause 4 is dead. So that's the thing I want. And the Assam government, if they were so confident about
You
it,
did
they
not,
never get it.
you challenged only a few provisions of the
No,
OM,
not
not
few
the,
provision. The most important provision was clause 4, where they denied the benefit of merit on the grounds that the court held that it's in violation of R.K. Sabharwal. It's a very clear-cut case, Lord. I'll leave it to you.
My lord, my learned friend says, division bench says appeal learned single judge's order in Bhagavan Patal. I'll just read 4 paragraphs. This is the judgment of the DB.
no, I think I've got it.
Okay.
This is the one.
My lord will first come to let me give a little brief background, my lord. A little bit. Just before I read the judgment.
No, anyway, can we decide anything today?
No.
Then,
Lordship will fix another day.
but you want me to see which para?
Yes, yes. My lord, our submission before the learned single judge as well as division bench was, there are 2 OMs. One is of 2014 and one is of 2016. In terms of which, according to us, the benefit given by 12/3/2002 and OM is no longer there. According to me, subject to what your lordships may say, division bench has upheld our contention qua 3816. But division bench has not said that according to 29/11/14 also the same position ensues. But regarding 3/8/2016, division bench has clearly said so. To come to that straightway, my lord will kindly come to page 34 of the judgment. In fact, 12/3/2002 has been qualified, has been explained. Now, same provision which obtains in 18/1/23 and based on which, my lord, currently promotions are being made. Please come to para 44. Now, as regards interpretation of clause 4 of the OM dated so and so, we again quote the said provision which is as below. If an occasion arises during the promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to promotion, his or her case shall be considered for promotion on merit if such candidate has not gained the seniority by way of an accelerated promotion earlier. My lord, I'm just pausing here for a moment, my lord. On qua 29/11/14, our plea was rejected by D. To that extent, I am with my learned friend. But qua this clause, our view has been upheld. Now, my lord, what does this say? Supposing in a promotional cadre, a reserve category candidate is there. Now, there is a further scope of promotion. Because he is already therefore he is entitled to be considered on merit. Because the moment he enters the cadre, he loses his earlier benchmark. Therefore, he is eligible to be considered now. Now, the clause 4 says, he will be further considered on merit against a general category post, provided he has not earned accelerated promotion earlier. In other words, by virtue of roster, if he has earned any promotion, then his further consideration will not be extended to him. That is the view, my lord, which is also 18/1/2003 also says that. Now let us see what the division bench has said. A reading of clause 4 makes it discernible that if an occasion arises during promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit are also entitled to promotion, his or her case are to be considered for promotion on merit only if such candidate has not given seniority by way of accelerated promotion. it would mean that if a reserve category is seeking for a promotion against any post in the promoted cadre, which is earmarked for reserve category candidate, he would be entitled to benefit of consequential seniority as provided in OM dated 12/3/2002. Now here is my lord, the explanation. That means such a candidate, if there is a further post reserved for reserve category, in which case seniority will be helpful. And that is the benefit we will get as per 12/3/2002. So this is the qualification and explanation, which my learned friend is not prepared to accept. But on the other hand, if the post earmarked for reserve category candidates are already exhausted by being occupied by reserve candidates, but in gradation list there remains some further category, reserve category candidates, they can compete for promotion against unreserved post. But in such an event, they would not be entitled to benefit under consequential seniority. On the other hand, if on the basis of seniority otherwise, without taking note of consequential seniority there within the zone of consideration, such candidate can be considered for promotion. So my lord, clause 4 has been upheld. Yes, qua 29, 11, 14, it was not upheld. But qua 3, 8, 16, it has been.
What does 14 say?
Yes, I'm coming to that. I'll just read para 46. Upon issues being raised in the present bill having been decided in the manner indicated above, it is further provided that decision rendered in the present judgment, so and so, would prevail over all such provisions of learned single judge in judgment dated so and so. That is Bhagavan Patar. But in respect of any other provision which may not be contrary or inconsistent with the provisions of this judgment, the same may prevail. But with a further clarification, if such any provision of the judgment of the learned single judge is in conflict or contradictory to any provision in the present judgment, such provision in judgment learned single judge stands modified accordingly. So learned division bench also said, my lord, that if there is any contrary view has been taken by any learned single judge, then it will not operate. Now, my lord, please come to para 19 of the judgment for the other plea, which was rejected. Page number 20.
Yes.
Mr. Ken Chaudhary, so-and-so appellant for the IV the Gohai Das Gupta on the other, and the other appellant in has raised the contention that by office memorandum dated 29/12/14, the consequential seniority meted to reserve category candidate by earlier office memorandum dated 12/3/2002 has been superseded, meaning thereby that provisions of consequential seniority pursuant to enabling provision of the Constitution 85th Amendment had been withdrawn. Accordingly, Ken Chaudhary Learned Senior Counsel assails the conclusion of the learned single judge. Now, para 20 regarding the other one, my lord. Now, my lord will kindly come to paragraph 29, where my contention qua 29 is rejected. Last 4 sentence, my lord. I'm not troubling your lordship. Para 29 at page 26 of the judgment, my lord. Last 4 lines. From such point of view, we are in agreement with Mr. Ken Chaudhary, Learned Senior Counsel, that office memorandum dated 29/12/14 could have also withdrawn the benefit of consequential seniority meted to the reserve category candidate by their earlier office memorandum. But at the same time, although enabling provision enables state authorities to withdraw such benefit, but what would further have to be examined as to whether office memorandum in fact withdraws the benefit of consequential seniority meted out by office memorandum dated so and so. Now, therefore, my lord, eventually, my lord will kindly come to paragraph 37 at page 30.
Yes.
Accordingly, on top, my lord, accordingly, it would have to be concluded that a conjoint reading of clause 1.11 and clause 14 of the OM dated so and so would mean that consequential seniority that was otherwise meted out by office matter has not been withdrawn. So the court was, the division bench was of the view that the benefit which was given by 12/3/2002 has not been withdrawn by my lord 29/11/14, a contention which we advanced, which has been rejected. But qua 3816, it said it cannot get it.
But has that 3816 superseded this 14?
No, madam. No, honorable division bench says now it has not been withdrawn, but it has been indirectly, it has been said it has been withdrawn by 3860. Because that particular clause has been given a meaning. It says that yes, this why it is said so, my lord, because 3816 says that this seniority which you have got by virtue of an accelerated promotion, you can utilize this only for filling up reserve category post. You cannot fight qua general category post. That's the, my lord, the purport of 3860. Therefore, to say that Bhagavan Pator's judgment has been upheld by the division bench, in my humble submission, is not correct. Just one paragraph. It has clarified everything.
Can't a clarification be sought for from the division bench?
No, the division bench has already clarified. I may read it once again, my lord.
But when there is, say, when there is a conflict
There's no
between
conflict.
14 and
No,
16,
only thing is, my lord, para 45, subject to what your lordship may say. In my humble submission, it is very clear. If your lordship kindly comes to page 34,
yes,
once again, my lord. I'm reading the 6th line. It would mean, as your lordship got
Yes.
it would mean that if a reserve category candidate is seeking for a promotion against any post in the promoted cadre, which is earmarked for reserve category candidate, you'd be entitled to the benefit of consequential seniority as provided in OM dated 12/3/2002. I'll pause here for a moment, my lord. In my humble understanding, in my humble comprehension, my lord, what the division benches say that the consequential seniority which you have earned following your accelerated promotion, that benefit of seniority you can utilize only for filling up a post which is meant to be filled up by promotion in a reserve post. Now,
well,
can't we see?
I get that. Now, let us see the 2014, the relevant provision.
OM, my lord.
OM, yes.
Yes. My lord,
Regarding this accelerated promotion, what are the-
My lord, one thing I'd like to clarify, 2014 has nothing to do with accelerated promotion.
Very well.
2014
Very
was
well.
brought in to
Very
give
well.
effect to the post-based reservation in terms of RK Sabha.
So very well, my lord.
So, and in
According
fact,
to him, it is
in
not
fact,
even
I'll
relevant.
answer what my learned friend has now said, I'll counter that why has he not read paragraph 39 and 40? Paragraph 39 and 40 clinches the show. It says that it will be cadre-wise, not group-wise, which the Assam government is doing. What they did, date of entry they took, and they made into group A and B. My lord, lordship will take up paragraph 45, I'll distinguish. Because
Let
the
me
entire
complete. Let me complete.
Yes,
By
my
way of reply, you may say so. Yes. By way of reply, you say so. No problem. Please come to page 34, my lord. I was reading para 45. Now I'll read from, but on the other hand, if the post earmarked for reserve category candidates are already exhausted by being occupied by reserve category candidates, but in the gradation list there remain some further reserve category candidates, they can compete for promotion against unreserved posts, but in such an event, they would not be entitled to the benefit under consequential seniority. And on the other hand, if on the basis of their seniority otherwise, without taking note of consequential seniority, they're within the zone of consideration, such candidate can be considered for promotion. Now, what 12/3/2002 said, my lord? The moment you earn a accelerated promotion, you will also be conferred with consequential seniority. Now, 3816 says that will not be there. It will be there only for the purpose of filling up posts on the which are earmarked for reserve category. So therefore, my lord, 12/3/2002 no longer holds the field. By necessary implication, my lord, that this 12/3/2002 has been superseded. Yes, my argument was based on two OMs. As my learned friend also, my lord, is in ad idem with me. He says 29, 12, 14 has got nothing to do with consequences. Very well. Lordship can record that submission, and Lordship need not go to the extent of finding out what does 29, 11, 14 say. Now, my lord, therefore, I will respectfully submit 12-3-2002 OM has been explained, rather it has been qualified by this para 45. So what's the wrong therefore committed by the government of Assam when it is giving promotion based on, my lord, the seniority, which has been fixed as per 18-123 OM? I don't think any clarification is required, my lord. Now, paragraph 39 and 40, which my lord will kindly see, if we are to accept the contention of the other side, that seniority be accepted cadre-wise, my lord, the Honorable Supreme Court has, in Ajit Singh, too long back has said it can't be done. Because when my lord, roster promotion takes place, there is no inter-se assessment between a general category candidate and a reserved category. All that happens is by virtue of roster, automatically one supersedes the general category candidate. Thereafter, when the general category candidate reaches their position, he regains his seniority. That is what is catch-up principle. And catch-up principle, my lord, is something which clause 4 of 3816 recognizes. So in such a scenario, to say that the Bhagavan Patra's judgment has been upheld by division bench is not correct. On the contrary, the learned division bench says, my lord, that even if view has been taken by any single judge contrary to what we have held, that is wrong. I don't think any further clarification is required.
But first of all, twofold submissions were made. As regards the issue of consequential seniority pursuant to 2002, that was the anchor sheet of argument that has been rejected by the single bench and the division bench, stating in clear terms that the 2002 giving the benefit of consequential seniority remains, is not withdrawn. So it remains. So the benefit on the 1648, no one.
How do you
as regards paragraph
45?
45, I have an explanation, my lord. If I read paragraph 45, the learned division bench held that you will get the seniority if you are within your own quota.
Correct.
But other thing, you will not be. Mala, we can ignore that part for the simple reason, because clause 4, paragraph 4 of R.K. Sabharwal says, when we go and compete on merit, we go as a member of the unreserved. So that paragraph 45, which my learned friend says is a statement, is a judgment, that paragraph goes in his favor, does not make any meaning whatsoever, for the simple reason our merit part cannot be taken out. What the Assam government has done, when we wanted to compete on merit, they say that you got it earlier by accelerated promotion. You have a tag mark, we will deny.
The problem
That
is,
has been cleared.
can I ignore the division bench judgment?
No, it is not. Bala, will your lordship definitely, if the division bench judgment is not in consonance with the Supreme Court, your lordship can definitely ignore it, because the division bench's order will be bound by the Supreme Court judgment. Because that is the reason I was saying the entire issue was cadre-based promotion. Because what has happened,
But
that is a settled position. My learned friend cannot have a different, because this cannot be argued perpetuity. One thing is settled, my lord, that the OM of 2002 giving us the benefit of consequential seniority is not withdrawn, and our promotion will be under the rules, that is cadre wise, which they denied. And in fact, we were brought down. Why are we before this court?
so according to you, promotion should be cadre-based.
Cadre wise in terms of the rules,
but not on the basis of seniority.
No, not on the basis of depriving us the benefit of merit by clause 4. That is our case. Because we got denied. Why did we approach this court? We approached this
merit.
Why we approached this court? All along we were getting accelerated promotion and seniority. It was only in 16 where they brought in a clause 4 saying that if you go on accelerated seniority, you will not give it the benefit when the question of you competing on merit comes in. That's the reason we approached this court. And our case was on the first round of litigation before the single bench. upheld on the ground of R.K. Sabharwal. R.K. Sabharwal is very clear. When we compete, you cannot put any fetters. It is unfettered. We will go as a member of the general. That's an admitted position. There are umpteen number of cases starting from R.K. Sabharwal, Saurav Yadav. There cannot be any dispute. If there is no dispute, the fact that the division bench has upheld the single judge's order and has held that the promotions will be cadre-wise, what is, because till now, Lordship, the funny part is that the personnel department, which is the nodal agency, does not they file affidavit with a one-liner. It is as per clause 4.
I think we'll have to read the judgment.
Yes, Lordship, what I say, Lordship, item 48 to 52, your Lordship will take up next Tuesday.
No, next Tuesday not possible. He was shaking his head. For one thing,
after we have agreed,
and not only that, plus we have got a lot of matters.
If the petitioner is ready, will your Lordship not allow that they be present and they make a submission?
Mr. Counsel, the court has to be ready also. It's not that we sit idle whole day.
Yes, but Lordship, your Lordship will also have to balance that the petitioners are also wanting an implementation of a judgment of a division bench. Lordship, at least a short date may be given. That I can pray only. And as regards the second part, Lordship, till the matter, the Langthasas case, which will clear the second impugn OM, because they took a cabinet decision overturning Bhagwan Patar. That's a very important, where we have consented to having a admission hearing. That may be fixed at a date, but till that date, Lordship will take up. Last time an order was there, it was not clear that they will not affect any promotion in any cadre. That protection I need. Because what has happened, during I coming to the court from 21, 3 promotions have happened. We have all assailed it, and we fear again, David, because they take up the plea, we are not complying with the division bench. That is very clear. Because the Assam government is taking a very categorical stand, will not comply. And oblivious of the fact that in a particular case of reservation, where my learned senior counsel, Mr. M.K. Chaudhary, appears,
but
there the Assam government supports
but this page 45 appears to support their cause.
Exactly. Page 45, para 45 supports their cause on a wrong premises, which is in violation of the Supreme Court. That I will satisfy on the next day. Lordship will hear it. I am fully prepared for it.
So there is a
dichotomy. Will your Lordship hold an order in violation of the R.K. Sabharwal? It's after.
Unfortunately, I am a single judge.
Is it file review, my lord?
Unfortunately, I am a single judge. You want implementation of the single bench order which has been upheld by the division bench.
Yes.
At the same time, you are saying that para 45 of the division bench order is
your Lordship has been a cursory glance has been made, because we are making a submission. Lordship will fix up on Tuesday, we'll make a submission. At least I am fully prepared to answer the query of my learned friend. I'm fully prepared, because I know my case hinges on a Supreme Court judgment. Because your Lordship, as regards the very
division bench is wrong, that is binding on your Lordship, Supreme Court says, until and unless that order is overturned. And that order has to be overturned, otherwise that will be binding.
Yes, well, has the Assam government went on appeal before the Supreme Court?
Why
have the private parties gone? So till the time they have not gone, can I not ask for an implementation? Because whatever is your Lordship.
Please understand that these issues that are being raised in this writ petition have already been thrashed out by the single bench and the division bench.
Yes.
Now, I am bound by the decision that Supreme Court has basically taken and decided issues in a general thing, not in regard to the fact that circumstances.
If the Supreme Court has decided things on a general, why is the learned single judge and the division bench referring to all the Supreme Court judgments?
Why don't you go to the division bench and say that your observation in para 45 is not in consonance with the Supreme Court judgment?
How can I go to the Supreme Court?
No, to the division bench.
If I go to the division bench, I will go to the division bench if on the next day, on my hearing and the hearing of a learned friend, your Lordship rejects my prayer, I'll go there. And there I will not urge anything. I'll want an implementation of the division bench's order before the division bench. There I'll definitely move. But why will I move when there is a single bench, Lordship is sitting, and definitely Lordship is bound by the division.
Aren't my hands tied? That's what.
Lordship's hands tied. Lordship has already taken a view. today or before the hearing, because we'll make.
No. It's a searching question.
No, no.
It's just prima facie view.
No, I'm also
It's not a
making
final view, but
Yes,
then I want to know your, you see, I've got to ask certain questions with regard to
Yes,
some
sir. And
doubts that I might
yes,
have.
and I'm prepared as a lawyer, as a counsel to answer all your, I'm fully prepared, Lordship. And this is the searching question I was making. If your Lordship rejects my prayer, I will have to move the division bench saying that my implementation order was not done. That's, I have to be fair enough. So Lordship, at least a short day may be fixed. That I can always ask for.
You can ask, but then depends upon the
No,
availability.
seeing the
He's
urgency,
also,
because they will also not-
your colleague has a problem.
on
Tuesday, my lord. Some other day,
On Tuesday, definitely I'll comment. I'm saying on Thursday, Lordship.
has an open both case fixed, sir. Lordship Thursday, Lordship has fixed even
Well,
my
at
two
least,
cases.
well, I have,
Ah.
on Tuesday, I have seen on the last occasion, I have.
Following week, Lordship can have it. Following Tuesday, Lordships can have it.
Following Tuesday, we have fixed that bunch of cases just now.
My lord.
That huge number.
Well, one thing, can your Lordship not put it on the Thursday? Let us make my part, I completed. That part can be done. I understand. Can I go on accommodating?
No. I don't do that type of thing. Because it's a problem with, I'm putting a burden on myself.
My lord, my lord.
Leave the
Friend
matter.
will definitely pursue his case. I'm
Yes,
ready to object that, my lord. But then the division bench has taken a clear view. Therefore, nothing further is there to be clarified.
He wants to have a hearing. Okay, we'll give him.
That I cannot approve.
Okay, right. On the prayer, the parties list the matter on 7th.
Oh, no, 7th is Lordship fixing on December.
Naturally.
That is.
Next week, so there's no chance. It's too full. This week and next week. This week, so there's no chance.
My lord,
Next week.
fifth, sixth, and seventh. The
That's
CB is fixed, my lord.
What?
Constitution bench matter is
Oh.
fixed on fifth, sixth, and seventh.
Then at least.
Let it be, my lord, after 15.
No, my lord, 30, 15, it will be difficult, Lord.
Okay, 14th.
My lord.
14th.
Well, then your Lordship will segregate this case from the
No,
other.
let all this matter, same point is involved, my lord. Why?
Well,
These are coming together.
The Lordship, I'll pray for the IA which I have filed. Till that time, your Lordship will injure.
No.
Well, that part can be given, that protection can be given because they have been flouting the orders repeatedly. I can ask for that. On that, my learned friend cannot have an objection.
No.
Because there is an order of Honorable Justice Jabir of the last day.
In an adversarial litigation, I have a right to object.
Correct.
No, they have already promoted. I'm not concerned about their promotion. Their promotion will be decided by your Lordship.
No.
But I'm concerned that we are moving down repeatedly. They are saying that we'll flout. We won't follow.
But prima facie, this 45 doesn't seem to be in your
Yes,
favor.
yes.
If I had prima facie found that there is something in your favor with regard to para 45, then okay. That is
Yes, but no, but look, as regards I'm not on this case. I'm concerned with the Langthasa's case. The next OM which I'm challenging, which is fixed on 50, item number 58. There I'm filed IA that the
OM dated?
OM dated 18 January 2023. They have brought a new OM where now they have overruled the Bhagwan Pata's judgment. There they are giving promotion because they removed the cadre purpose and they made it to categorize it into A and B groups. Groups cannot be made. They made it to group A and B. Only group A will
But
get
that's a different issue.
My lord.
Yes. No, it's an issue arising from this. But I am asking that during the pending, till the matter is decided, at least.
This is matter of 40 on the present
Yes,
parties.
yes.
Then the item 58. Give me item 58.
Yes, 58.
No, my lord, there I have a serious objection, my lord. There can be no interim.
I want to know what the issue is.
Yes,
It
yes.
is
My
different.
lord, though my learned friend would like to say that seniority or promotion should be based on cadre wise. But the larger issue is involved. Who enters the cadre by what means? Somebody by virtue of my lord.
My question is
Yes.
that item 58.
Yes.
It will be covered by this division bench judgment.
Eventually, yes. Everything will be covered, my lord. His case is, my lord, all along he never got seniority by virtue of cadre. He entered the cadre much later, my lord, as an assistant engineer.
I
By
got it
virtue of
by
roster
cadre.
only, he was jumping. So then, my lord, my learned friend was very happy. So now a parity has been restored, where Assam government's policies, my lord, there will be accelerated promotion, but there will be no accelerated consequential seniority. Why Assam government? My learned friend has made an argument that they have taken a wrong decision. Because in Bhagavan Pata's case, my lord, the learned single judge has made a clear observation that it is for the state to have both accelerated promotion and consequential seniority, or accelerated promotion alone and no consequential seniority. Precisely that has been done by the government, and that is how 18-123 has been issued. Now he has put a challenge to that.
18-123 to correct
Same,
2002.
no, my lord. Yes, to care of 2002. And my lord, it reiterates the position as in 3816, clause 4, same position. So now he wants, despite all these things, without interfering with 18-123, my lord, their seniority should be retained and they should be
Well, then
promoted.
he should be prepared
That
for
can
hearing.
be a-
Why is he repeatedly taking time?
Who is
the-
repeatedly taking time?
On the last occasion also, my learned friend has
Even now
taken
I'm
time.
prepared to argue.
Then if he is prepared to argue, Lordship will fix it. I'll make my submission. On the last occasion, time was sought. Because time, basically, Supreme Court has said, once you adjourn the matter, status quo goes in favor of the respondent state. That's the thing they are getting the benefit. And I say that if he is not prepared for the case, can I not say that my IA, which is there, they are going out with promotion, can you not, Lordship, injunct that part? In fact, Honorable Justice Jamil has already injuncted. I want a reiteration of that order.
my lord,
In
nothing
fact, there's
has-
the last
nothing
day
of this
addition
Show me the order.
Yes, of the last day order.
No, my lord, this aspect of
Last
the
one.
matter was gone into. That order was never passed by this honorable court. If he wants further, let him file an IA. We'll file
Well,
objection.
There is already an IA. They have been given to party copies. There's an order on the last
My lord,
occasion. Lordship.
can interim order be repeated, my lord, every time there is a
Yes,
refusal?
my lord, all the facts of the case, it can be repeated for the ends of justice.
Show me the order.
Yes, there's an order. Yes, because it has jumped. My lord, last
I think the
order of
Jamil's
honorable
order was
justice.
subject to the outcome.
No, not sir. My lord, what has
Huh?
happened? The Jamil's
Huh?
honorable Justice Jamil, on my prayer, they passed an order that they
No, my
said no promotion will be
I
affected
think
till
my
the matter is
learned
decided.
friend can clarify the position, my lord.
Go ahead.
Go ahead.
Always say interim order not considered because the council is paying for the part.
Yes.
That knows the movie.
That's all.
That is.
Done.
Where is
Then-
is it reflected?
Number 50, no I is there. Item number 15, where is the?
Malad, it's an order dated 7/11/2023. Malad, let my learned counsel not bring issues of whether I filed or not. Malad, on
My lord,
merits, they
order
should file.
dated 7/11/23.
It's very.
The learned standing council appearing for PWD and
11/7/23.
7/11/23.
In which item? In which
Yes.
writ petition?
Malad, in.
IA, my lord. Huh? My lord, I think this order was passed in writ petition.
In pending 3094.
Item 52, my lord.
3094.
Item 52.
Learned Standing Council appearing for PWD and Water Resource Department submits that there is no move for any promotion in the cadre of Assistant Engineer in PWD and in the cadre of Chief Engineer in Water Resource Department at this stage. Therefore, prayer for interim relief made by the Learned Council for the petitioner is not considered today.
Today, yes. It left it for today. So today I'm pressing for it.
So today, has the government said we are going ahead with the proposal?
My learned friend will
Yes,
have to
I will.
clarify whether he is
Is
speaking for
there
the
any
government.
promotion process in the office?
Find my opposition document.
No, filing is a different issue. I am asking you a question. Either you say yes or no.
On the date, it's a 5 days by inspection process.
No. Do you have any knowledge? Whether there is any promotion process?
State submission was taken for that.
7/11. Today is my lord, Aditya Matari. 15, only 1 week back.
Because
Is there any IA in this case? No, they have read it out. They have read out the order. In
7/11/23. Just the number.
no WPC.
Item 52, my lord.
Item 52. Give me item 50. 52 is here. IA is there.
my eye is there, man. All eyes are there. In fact, on my submission, this order was passed. So I want an extension of the, can I not ask for an
Three zero nine four WPC.
3094. Is there I? There must be I. There's no I. Yes.
There are
It is in the main writ petition.
Yes, in the main report.
The learned standing council appearing for the PWD and water resources submit that there is no move for any promotion in the cadre of assistant engineer in the PWD and in the cadre of chief engineer in the water resource
Yes.
department. And your case is with regard to
My case
which department?
is till chief engineer because
which department?
there are three departments: the Department of PWD, the Department of Water Resources, and the Assam Civil Service. These are-
But then you have asked if 58 pertains to which department?
These are water. resource and
58
PW.
department, 58 is a Water Resources Department. 58, yes, 58 is Water Resource. PWD department. PWD, because my entire challenges is of three departments. One is PWD,
Yes.
Water Resources, and Civil Service.
So is there any move for promotion?
That I can.
You get it by 2 o'clock. Then you get it. Then we'll record your submission and we'll give the same order.
Yes.
I'll pass the order then this training.
Or this can be continued till 14.
Yes.
Then come over.
No, but unless this cannot be, he has to get instructions.
Okay. My lord. Yes.
It will not be proper. You get instructions by 2 or within 10 minutes. You just ask them.
2 o'clock. 2 o'clock. 2 o'clock.
Otherwise, we might have to restrain. I don't know. Let's see. You get it by 2. There's item 58, just leave it blank. Huh?
Or can it be tomorrow, my lord? Second half, I have some difficulty. Just start ceremony.
No, it's only with regard
regard to
to instruction.
We have to make submission on merit.
My lord, on the submission of the government
Yes.
stand, how can my learned friend
merit, I can always say.
We'll see.
on
We'll see.
merit?
Let it be tomorrow, my lord.
No, not tomorrow, not tomorrow.
Let it be
Tomorrow,
okay.
tomorrow.
Tomorrow,
Tomorrow,
second half, I have some personal difficulty, extreme personal.
This
Some
will be
start
decided
ceremony in the family, my lord.
only
I
with
have
the
to-
government, and the lordship will decide that is stand
Yes.
of the government.
I just
the
want his
private
instructions.
No, my lord, my learned friend as a counsel representing the petitioner, he will make some argument
Let us
on
see.
based on prima facie detachment.
No, let
That I
us.
have a right to object.
No, you have a
No.
right to object,
Yes.
but the right of giving a date is my prerogative.
No, I am not saying about date. Date is lordship.
So
I
that,
am only saying if it is possible tomorrow, my lord.
no, let's see. Let us get the instruction from the government. Depending upon that, I'll decide.
In fact, on my submission, Honorable Justice.
All right, that's 2 o'clock. I'll be
At
there.
2 o'clock.
Okay, at 2 o'clock.
Of like.
This matter is similar to the, let's say the series matter from item 4 to 45 matter. Exactly identical. Let's say we'll fix it along with those matters.
Okay, right. Tag this matter along with WPC number 5281 of 2016 and list the matter on
On 5th December.
5th December.
My lord, till today, they have not filed any affidavit.
I will come up with that.
I mean, the
It's not
issue is
okay.
there's nothing, yes.
Only the persons are grade 4 employee. Others are
Yeah,
teachers.
those are teachers. Oh,
Same time, there are-
no, they don't say tag. Then list this
Yes,
matter
my
on,
lord.
list this matter on 5th December.
Fifth.
You're a grade 4.
Grade 4. They are not paying salaries, my lord.
Exactly same issue is involved.
On
Where is the
basis of
question
court
of, those are
on the
teachers.
basis of court
Same
order,
retail
they
my
have
lord,
been
it-
regularized, my
Huh?
lord.
82, that retail itself, they're,
Maybe, but then they're a different class of person.
Yes, my lord.
then what you will fix it on 5th December. We'll consider on.
No, what is your case? That you were
My lord,
terminated.
yes, terminated. Then again, they have been
Regularized.
regularized because of court order, my lord.
2015.
Yes. Only
And but
petition,
you have not been given pay.
yes, my lord.
That is your case.
That is my
And
case.
do you want that is only that's your
Yes, my
prayer.
lord. That
Only
is my
pay.
prayer. Yes, my lord.
Nothing
Only I have
regard.
come for
You have not asked for payment of salary prior to 2015.
No.
At the end, what
From
is
the
there?
15th,
Why
my
should,
lord,
why
after
should
the
we,
regularization.
why should we, do it on that day?
That sanction, we have asked for sanction of this board.
That is a different issue.
Then
Sanction, non-sanction, that is a different issue. The issue is whether the petitioner has a right
only that,
to get the salary
yes,
say,
salary,
from the date of her regularization.
my lord, that we have asked for sanction. The moment the sanction comes, when we release it, my lord. But without, because the finance is not the subject matter of the BTC. That's the difficulty.
I'm not on that. I'm not on that. You see, the issue is this, whether the petitioner has the right to get the salary from the date of regularization.
That same issue is involved in. other
Correct.
cases.
So what is your
But I'll
submission?
come up with the affidavit, my lord.
No need, no need. You give me this case. What is it? Item
Item 60.
60, yes. That's it. Why affidavit when the law is clear? Why aren't you paying them the current salary? Yes, where is your appointment order, initial appointment order?
Lordship, initial appointment is Lordship. Page 38, Annexure 3. After that, they have been terminated. my
Page
lord.
38.
38, initial appointment. And it is written in person of the government post sanction order memo 91, service of the city signature, Polita class 9, appointed by the managing committee of the school is hereby regularized with the immediate effect in the scale of pay. Then they have been received the salaries also, my lord, up to
No, no,
2010.
no, this is of 99.
99. After that, they have been terminated. Then on
Where is the termination order?
Latest, my lord, that is page, my lord, latest order is page 100. 110. That is the 110 is the my lord termination order, my lord. Then they have been regularized on the basis of coach order. The
Let us see the court
is
order.
123 coach order. That the council appearing on BTC submits that policy decision is taken.
123.
120, 24.
123 start from 123.
Starts from 123, my lord. Relevant portion, my lord. Salaries from the month of March 2006 should be regularized and implemented.
Okay, so
Then they have been
no, just
regularized.
madam.
Yes, my lord.
This is with regard to WA 182.
Yes, my lord.
What is your case number, writ petition number? How do we do this? This pertains to teachers. This WA order pertains to teachers.
My
And
lord,
you are grade four.
peruse 125, my lord.
Yes.
Yes, my lord. The impartial of the Honorable Guwahati High Court judgment dated passed in WPC, the writ appeal number, batch of Nishkesh, my lord, that is the service of the order depend from the end is hereby withdrawn and his service is regularized, reinstated as a grade 4 in Dihira MD school in the scale of pay 4,000 to 560 and grade pay 1,500 plus other admissible allowance. Since then, they have not been received, mother. That is one of
And you are working.
Yes, they are still working, mother. This is my case.
So what is the only thing is that she's entitled to the payment. When you give her, you have got to give her the money. Just because you have not been given the sanction by the government, doesn't mean that we cannot dispose of this case.
Because
And then we'll take it up. Then she'll file a contempt. Then you'll start paying.
already,
Yes,
already 1316 posts for sanction for 1316 already been sent to the education department. Thereafter, it has been sent to the welfare department, sent it to the finance department. The moment that approval comes, my lord.
What do you mean? But you have regularized, correct?
Yes, yes.
Where is the regularization order again?
My lord, that is
Page
page
125.
125, my lord.
All have
In pursuant of the government, Honorable Guwahati High Court's judgment order dated 6/2/2015, passed in writ appeal number 128/2013, batch.
Yes.
Yes, my lord.
So now
It
you
is
you
withdrawn
see,
and regularized,
regularization
reinstated.
has been done. The only
Regularized and
thing is that
reinstated
the only
as
thing
again
is that you have got to pay as soon as you get the money.
But first of all, if you get the sanction, my lord, I'll do it.
So, Mr. Counsel, you have regularized this person in 2015.
15 years, my lord.
That means you have waited for the money for 8 years. And you have availed the services of the petitioner for 8 years, free of cost.
But-
Then, is it fair? Now let them file some contempt cases, then we'll see how you
Well-
cannot just deny the benefits of the service rendered by the petitioner.
In the meantime, my lord, there is a development that 109 persons have been sanctioned, manner, they have been regularized. And this is the person who is left out in that. Among the left out person, we have already got sanction for another 1300.
We don't know, why did you regularize the petitioner if sanction was not taken, prior sanction was not taken? That's your headache. You should not have regularized.
That government has taken up the decision that the other government has taken. Up.
Okay, anyway, I think, right, heard Miss
KDB.
K. Devi. Learned counsel for the petitioners. And Mr. S. Bora, learned counsel for the
BTC.
BTC. Who else appears?
Lordship, I appear for respondent number 6 finance.
Mr. A. Chaliha appears for respondent number 6. The petitioner's case is that, no, the petitioner, by way of this writ petition, has prayed for has prayed for a direction to be issued to the respondent authorities to pay their salaries with effect from 5/10/2015, comma, that is the date the petitioner's services, no, that is the date the services of the petitioners but the petitioner has prayed for was regularized
In different schools.
in different MV schools. MV schools. With effect from 1/10/2015.
110 and someone is different dates.
Acha, with prospective
Yes,
effect,
prospective.
with prospective
Yes.
effect. In terms of the order dated
Order dated
1/10,
110.
all 1/10.
All.
You have put only one order.
110, my lord, no, my lord, not all. But one is 29 October.
Where is
And
the order?
that is page 126.
Others all are 1/10.
Yes, my lord, 110, most of it, yes.
No, you've
110.
got to be clear.
110, my lord, all 110.
No, some is 14/10 also.
Is it? Yes, my lord, 1410, that is 127. Then, my lord, others are 110.
In terms of the orders dated 1/10, 2015, comma,
29,
14/10,
10, yes.
2015, and 14/10, 2015.
One ten, 110. 110, 110. One is 28 March 2018 and one is 29 October 2015. 14 October, my God.
The next para, the petitioner's case is that in pursuant to an advertisement inviting applications for filling up grade 4 vacancies, the grade 4 vacancies in ME schools or MV,
ME school, ME/NV, both. are
ME
same.
/ MV school,
Yes, madam.
comma. The petitioners were selected and appointed as grade 4 employees. However, the services of the petitioners were terminated
19 January 2009.
by 19/1/2019, 2009. No, by order dated 19/1/2009, issued by the Director of Education, comma, BTC. The petitioners approached this court by how many, what is the writ petition? Your petition is incomplete. There's no, what is the writ petition that you filed?
Yes, my lord, it is.
What is the writ petition, madam?
Yes, my lord. My lord, they have terminated.
I'm not on termination.
Yes,
What is
yes,
the
my
writ
lord.
petition that you
Writ
filed?
petition, I did not mention, my lord. in the-
The petitioners filed writ petition before this court. And what happened before the single judge?
It is not 17, my lord.
And the learned
After
single
passing
judge
this order, my lord,
found that
they have been regularized.
the orders of appointment of the petitioners had been illegally issued. And also found that the termination was legal. Termination of the petitioner's service was proper. Thereafter, WA number 182 of 2000 No, thereafter,
180.
various writ appeals were filed. Inasmuch as the termination of the petitioners who are grade 4 employees and termination of teachers were taken up in a batch of writ appeals, the lead case being WA number 182/2030. WA number 182/2030 and other writ appeals were disposed of by an order dated 6/2/2050 by recording the fact that the BTC had taken a policy decision to regularize the services of the terminated grade 4 employees and teachers who had received a regular salary up to 17/10/2006. Next paragraph. In pursuance to the order dated 6/2/2015, passed in WA number 182/2030 and other writ appeals. The Director of Education, Bodoland, the BTC, withdrew the termination orders of the petitioners and regularized them with prospective effect. Wide orders dated 1/10/2015, 14/10/2015 and 29/10/2015. Next. The petitioners' counsel submits that though the petitioners have been working as regularized grade 4 employees in terms of the orders dated 1/10/2015, 14/10/2015 and 29/10/2015, they have not been given their monthly salary from the date of their regularization. From the date of the regularization. Next paragraph. Mr. S. Bora, the learned counsel for the BTC, submits that. What do you submit? That sanction has been, sanction proposal, the proposal for sanction of the salary payable to the petitioners has been forwarded
to the Department of Education.
to the Department of Education,
Education has forwarded to the Finance Department.
who in turn has forwarded the same to the Finance Department. Full stop. However, the Finance Department has still not sanctioned the amount payable to the petitioners. The amount to say the salary, the salary, instead of amount of salary. Yeah. Next, Mr. A. Chaliha, the learned counsel for the Finance Department, submits that he has no instructions.
These are a submission made by my learned.
Submits that he has,
Bottom record.
submits that he has no instructions with regard to. He submits that he has no instructions with regard to whether the BTC and the Education Department have forwarded the proposal for sanction of the petitioner's salary to the finance department. That's all.
Yes, sir. I mean,
Some document you have to produce. I think we'll call your officer. Who do we call BTC? Let him come.
Fifth, my lord, will get the.
Huh?
In the, that will fix it on fifth, my lord.
Why? Why fifth? I think we'll call him.
My lord, so will. Fix will get the, all the information, my lord. What the
Okay,
contract
okay.
is.
We won't dispose it out. Let us get some solid document. Good stuff. Next para.
Everyone
Uh,
known the known
list the matter on next week. List the matter on. Twenty-fourth. 24th. Full stop. The Mr. S. Bora shall produce the proposal for sanction of the salary of the petitioners and other teachers whose services have been regularized in October 2015. What have I said? Comma, which has been forwarded to the education department and subsequently to the finance department on the next date. Full stop. In the event Mr. S. Bora does not produce the records and the forwarding letter as in the comma as indicated above, the presence of the Principal Secretary, Department of Education, BTC, Kokrajhar, will be called for.
problem.
Right. No one appears for the petitioner on call. The petitioner is claiming family pension on account of the death of her husband, who is a regularized master roll worker. Full stop. Next para. Para 7 of the affidavit in opposition filed by the respondent number 8 is to the effect that the father of the petitioner, comma, namely Shri Rakhal Mazumdar, has stated before the Judicial Magistrate Sankar Nagar, Hojai, via a letter that the petitioner had already remarried one Mukesh Chetri, resident of Lumding Relief Yard on 27/7/2002. Full stop. In view of the above, it appears that the petitioner does not have any right to claim family pension for the death of her husband, late Moni Kantaroy, Moni, Kantaroy, who died in harness on 15/12/2019. There's something wrong somewhere. 2019 died. And this lady married in 2002 already.
Get divorced in 1997.
Divorce, where have you said that?
58.
Page 58.
Yes, of our.
First up, the letter written by Sri Rakhal Mazumdar to the district judicial magistrate. District judicial magistrate also states that the petitioner had divorced her husband in the year 1997. First up. The petitioner is not here, unfortunately. Just say, as the petitioner is not, there's no one represents the petitioner. The matter may be listed on Monday. Let us wait. One chance we'll give and then we'll dismiss for non-prosecution, reflecting this.
In the morning, I made a prayer, my lord. I need to file a reply to their counter application.
What is this matter regarding?
This is, my lord, I have been removed from service. I have been convicted. I served. Then I asked for the pensionary benefits what have accrued during the time when I served before my dismissal. Now those components which were deducted from my salary. Now CPF has been paid. Now one matter is seeking gratuity and the other is seeking the remaining pensionary benefits, whatever components are there during that time before my from service. That is all. And if your lordship sees my prayer, my lord, I'm simply asking for a mandamus to calculate and release. I'm not saying give me so and so amount, just to calculate and release. Even if I am entitled to 50,000 rupees or 1 lakh rupees or whatever, as on that they have not taken any decision.
They have filed an affidavit.
They have filed an affidavit. They say that I'm not entitled to gratuity under so and so. As per their own service rules, I'm not entitled.
You are terminated from service.
Yes, I was terminated.
Then why should you be entitled to anything?
My lord, I'm not asking for pension, my lord. I'm asking for those components which were deducted from my salary when I served. Those are not the property of my employer. I'm entitled to those components. That is all.
When have you come to the court?
My lord, I came immediately after I was released from prison. I asserted my right immediately after I was released from prison. And then they paid me CPF, meaning thereby it was admitted on their part, but the remaining dues they kept out of it. Then I preferred multiple representations, then the first petition, then the instant petition in the year 2022. And all this while, they have not paid any other component. except the CPF. Payment of CPF itself is an.
No, tell me, what are you entitled to?
My lord,
You have to claim your right. What are you entitled to?
my lord, it is, the burden is on them, my lord. They have the service rules. They have to say which components I am entitled to, my lord. I am simply asking for whatever.
They are saying you're not entitled to anything.
Yes.
Now you have got to show that you're entitled to something.
My lord, in only one paragraph, they have stated that I am not entitled to leave or traveling or something. My lord, where's the rules? They have not annexed the rules. At least lordship would kindly.
Mr. Counsel, you have got to stand on your own legs. You cannot try to
My lord,
build
they
your
cannot
case
come in.
on the weakness of
Once I
others.
file the repetition, they cannot come and then refute, my lord. They have to take a decision in their executive level. Rejecting my prayer, all this while which I have been making. Not a single decision taken all this while. Otherwise, also, when I first asserted my right, they paid me the CPF.
Mr. Counsel, don't, you see, this court is asking you, forget them. This court is asking you, what is your right? And with regard to the claims that you are making. Show me. What are the claims you are making? You show me.
My lord, the
I'll dispose of the entire thing now.
those are not stated, my lord. My prayer is simple, my lord, to simply calculate and release the.
No, so yes, so they are saying that you're not
I
entitled
am
to
unable
anything.
to place those components, ma'am,
Then
to what I am entitled to. My lord, I have been dismissed in the year 1999. I served, and then I was released from prison also. My lord, nowhere am I connected to that particular office, and I don't have all those documents. I don't have access to them also, my. And that's why my prayer, mother. I'm not saying that you pay me so and so amount. I'm simply saying calculate, and if I am entitled to, then release it. If in the executive level they take a decision that I'm not entitled to any amount, then fine. Ma'am.
just a minute. Where is the decision of this court and the appeal? Great appeal?
Madam.
You have not annexed.
My lord, writ appeal, as in my lord, again.
Have you mentioned in your writ petition that you had made a challenge?
The criminal appeal judgment is there, madam.
Where is that?
Criminal appeal judgment. Page 34. Followed by the Supreme Court judgment.
Just get me this file. WPC 1965 of 2007.
My lord, the order is there.
Where?
My lord, page 54. That petition was seeking reinstatement. Page 54. Yes, ma'am.
What has happened to the SLP?
My lord, the SLP got over before that, my lord. The SLP order is at page 48. And immediately I surrendered and I served for 1 year.
Page 48.
Yes, ma'am. That is the SLP order.
SLP dismissed.
Yes, ma'am. Dismissed, then I surrendered. I served. Once I come out, then I prefer a representation asking for all these benefits. And they pay me the CPF.
Yes, what is your stand taken in your affidavit?
Petitioner never raised any claim with respect of his terminal dues till 22 years from the date of dismissal of termination from the service of ONGC and almost 8 years from the date of judgment
Dismissed when?
from the service of ONGC. Order dated
It is
1905
Order of dismissal dated
1999.
1999.
Their delay lordship and lordship they have raised for terminal dues lordship terminal dues relating terminal dues lordship kindly see para 18.
Para 18 of the writ petition?
Yes. Of the affidavit. Reply.
Para?
Reply filed by ONGC. Para 18.
Para 18.
Yes. Page 77.
Page 77. Para 18. 77.
The answer
There is no 77, Mr. Council. Para 18 of the reply.
reply.
There is no para 18.
Perhaps your lordship is checking up the first matter. My lord, there's the WPC.
Yes, give me there are two repetitions over.
Yes, ma'am.
Yes, there's another one. Give me. Give me the other repetition.
Second.
What are you praying for in these two repetitions? Same
Well, the
person.
first one, he filed seeking gratuity and the
Seeking?
gratuity. And the second one, the remaining dues. ma'am. Whatever dues, I am entitled.
Page 7. There's no 77 in this other. In which affidavit, in which case?
Lordship, 1417 of 2022.
1417.
Yes, Lord.
This is 1417. Now out here I've got this 1417. What is WPC 1595 affidavit here? 1417.
Yes, Lord.
Para?
Para 18, Lordship.
18.
Lord.
Para 18. Yes.
The answering impact of terminal dues as a consequence of termination of services dismissal as major penalty as mentioned below, Lordship. The relevant provision governing the issue of terminal dues are covered by clause 9 of Schedule 3 Executive Instruction and Clarification and B Rule 41B 3 of ONGC CDA Rules 1994, Lordship. Lordship, gratuity can be forfeited if dismissal is due to loss or destruction of property of the company. Gratuity forfeiture is limited to the extent of such damage or loss, full or partial, to be specified in the penalty order. Forfeiture if dismissal is on account of riotous, disorderly or violent act or on account of moral turpitude committed in the course of employment. Hence, gratuity is not admissible. Also, engagement of half pay leave is not admissible under Rule 22(2) of Leave Rule 1995. Also, earned leave engagement is admissible only if the employee is compulsorily retired as measure of punishment under CDA rules, but earned leave engagement is not payable in case of removal or dismissal. And 5, Lordship, existing scheme does not allow the facility of post-retirement medical benefits to those who are removed, dismissed from services. And 6, Lordship, transfer prevailing allowances TTA is not admissible under the present TA regulation.
Let us see these executive instructions.
Lordship.
Have you got it? Let us see the executive instructions. Where is it? You see, para 18(1).
Lordship.
The issue of terminal dues are covered by A clause 9 of the schedule.
Yes.
Where is this? Where is the book?
Lordship. CDA, this is the CDA rule, Lordship.
Huh?
CDA rule.
Okay, and where does it talk about gratuity can be forfeited if dismissal is due? How much gratuity is he entitled to?
Lordship, there is a table, Lordship, in this.
So how do you know? How do you know? Because it says gratuity can be forfeited if dismissal is due to loss to or destruction of property of the company.
Lordship, according to the
Can be dismissed due to loss of okay. Gratuity forfeiture is limited to the extent of such damage or loss.
Lordship.
So how much should he have been given
Lordship.
actually?
Lordship, this is a writ petition 1595 reply. Lord, reply of writ petition number 1595.
Yes.
Lordship, may kindly see.
Yes.
Lordship, kindly see para 11.
Para 11.
11, Lordship.
Yes.
Lordship, the answering deponent begs to state that petitioner, while making the said representation, did not mention anything about his service record. When concerned office of respondent number 1 went through his service record, it was found that petitioner was convicted for imprisonment of 1 year by learned special judge Guwahati by judgment dated 24/9/1996, passed in special case number 1C of 1988 under section 120B, 468, 471, 420 IBC and under section 5 to read with section 51D of Prevention of Corruption Act. 1988, as he had resulted in financial loss of rupees 2,20,000 by way of forgery and criminal conspiracy. Further, his criminal act come under the definition of offense involving moral turpitude, and hence petitioner is not entitled to any gratuity, as the respondent obviously has right to fully forfeit gratuity amount of the petitioner as per settled provision of law. It is also be stated that petitioner preferred criminal appeal number 266 of 1996 before Honorable Guwahati High Court against the said judgment dated.
Okay, okay. If due to moral turpitude, the entire thing can be taken away.
Yeah.
That is there.
And terminal relating to terminal dues, Lordship, there is a table in the CTA rules. Lordship, and
What is rule 22(2) of leave rules? What does it say? Encashment of half pay leave is not admissible under 22(2) of leave rules. What is this 22(2)? What does it say?
Lordship, this is not in my instruction. It is sometime maybe email Lordship. On next day, I will.
You see, one thing is that you are saying half pay rules not admissible under 22(2). Show me 22(2). Then you say earned leave encashment is admissible only if employee is compulsory retired, but earned leave encashment is not payable in case of removal and dismissal. Where is that? Where is it written? Is it written here?
Lordship, there is only one copy, Lordship.
No, no. You look at it and you tell me. Take it up at 2. At 2 o'clock. You look at it. Where is that provision 22(2) and a half?
Okay.
At 2.
May I please, Lordship? My lord, this is regarding family pension, my lord, between two wives, my lord, and I am.
Between two wives.
Family pension. I am the first wife, my lord. But the respondent number 9, my lord, second wife is receiving the family pension, my lord. Kindly see next of kin, my lord, I have annexed page 30, my lord. And the couple is governed by Hindu law, my lord. The violation of section 5, my lord. That is another aspect, my lord. Kindly see page 30-31. Relevant 31, my lord.
Para?
31, my lord. Annexer, my lord.
Yes, who's for the respondent number 9?
Nine, my lord, have not come up, my lord. I have taken Dusty also, my lord, and Lazima court, my lord, confirmed.
Okay.
Thereafter, my lord, Dusty service was taken, but she has not, my lord, come up. I'm the first wife, my lord, Elizabeth 31, Dibbolata Hadrika. This is my lord, next of kin. And kindly see my lord, death certificate, my lord, page 29.
Yes, who's for the state?
Also, I am for the department losses. My instruction dated 10, 3rd October is that losses. The husband of the petitioner had furnished the nominee on the service record, the name of the second wife, lordship. And this instruction is there, lordship.
You're asking for family pension.
Lordship, he is asking for the family pension. Because the husband of the petitioner has died.
So let them go to civil court then.
No, my lord.
What to do?
This is, my lord, now, my lord, the couple is, my lord, governed by Hindu law, my lord, that is another.
No, that the law is clear. The facts are not clear. You are saying that you are the first wife.
First wife, my lord.
Husband has given the name of second wife as his wife, has not given your name. So this issue will require evidence. So you go to civil court.
No, my lord, director of pension, my lord, has filed affidavit, my lord, saying that we were not aware of the second wife. So behind
that is what.
Behind the back, my lord.
Correct. But then these are disputed questions of fact.
No, my lord, these cases are disposed of by this honorable court also under Article 226.
No,
I have alleged one order also, my lord.
But
Similar order. And lordship, after that instruction is lordship that upon receipt of the complaint from the first wife, lordship, the director of pension has restored the pension to the second wife also.
Yes, stop the second wife. Guess what? I think that order.
And they are suffering, my lord.
Maybe suffering.
And my lord, long time.
I doubt you are suffering. I think you are probably living separate, maybe, and not suffering. The issue is with regard to facts, whether you are the first wife or the second wife, we do not know.
And that was directed to bring, my lord.
So they have brought out according to the family form 3, I think, no? Is it form 3?
Form 3, I think.
You see, the government servant has to fill up a form.
Lordship.
Family declaration.
Lordship. That nominee is there.
And out there is the wife is shown as the respondent number 12. 9. So then that's a disputed question of fact.
That is the behind.
Maybe, but then we do not know.
Kindly see, my lord.
Only you know the truth.
No, NOK, my lord.
Only you know the truth. That is the
my lord, death certificate, NOK, every record, my lord, I have.
So you prove that in the civil court.
No, my lord, that is not. She is not coming, my
She's
lord.
not coming.
I have taken Dusty also. She is not coming. She is not interested. She knows the consequence, my lord.
Where does it say that notice is served?
Notice is served, my lord. That is recorded. It was before the Lazima court also, my lord. And my lord, Dusty service, my lord, in terms of the order dated.
Retired head teacher. The second the respondent number 9 is the retired head teacher.
Hello. Wife of the retired head teacher.
Okay.
She is the housewife. Respondent number 9 is the second wife.
No, please come to the order dated 14/9/23.
14/9/23.
List this matter on so and so, enabling the treasury officer represented by so and so to apprise the court the amount of death gratuity paid to the respondent number 9. Srimati Joyti Datta, second wife of late Baba Kanta Datta, alias so and so, a retired head teacher. Okay, maybe the.
Yes. He was the, my lord, head teacher, husband.
Duly served.
Duly served. And Dusty also I have taken.
Where is the thing? the citation that the first wife should be given?
First wife should be given, my lord. This is, my lord, in Zunuba Bibi versus Musammat Padma Begum, my lord. This is by full.
Yes,
length, my
what to do? The second wife is not coming.
lord. Is not coming. My lord.
Okay, right. Heard Mr.
AF Anu Mullah.
FAFNU Mola, learned counsel for the petition. Are you sure the respondent number 9 is still alive?
Alive,
I do not know.
alive.
You could be playing a game with us.
No, my lord. It should be recorded, my lord.
We have to prove that.
He has to prove that he's the wife.
That's the question of fact.
It's a question of fact.
No, but I have given my death certificate, my lord, then LOK, my lord, next of kin. Issued by Deputy Commissioner, my lord. Page 29, my lord, that is my name, my lord. Dibolata Hazarika.
We do not know. Maybe second wife, respondent number 9 has expired and you have come to this court to take
No, my lord.
the money.
Then let the instruction may come, my lord, regarding that effect, my lord.
This is also dusty service.
That is also.
We do not know.
Dusty, I have filed affidavit, my lord.
Only problem is that this court had stopped the payment of
To the
family
second wife.
pension and still not come. But then he has to prove, I think.
He has to prove yes. Who is the first? He has to establish the case first.
I think best way to establish is to whom, but that he says that this the next of kin certificate is there. Is that enough or not?
And death certificate also, my lord.
That certificate is nothing.
And next of kin, my lord, that is a record, my lord.
That certificate, so you can always get with the connivance of.
And many other records, my lord, I have given.
Next of kin, can we rely on next of kin certificate? Anyway, we'll take it up at 2. She's the first wife of the late Baba Kanta Datta. Baba Kanta Datta. And as such, she should be given the family pension. On the other hand, it is the case of the state respondents. And before that, you write. And before that, it appears, huh? No one appears for the respondent number 9. So, this court, in its though this court in its order dated 7/6/2023 has held that petitioner has taken steps for service of notice upon the respondent number 9 by way of dusting. Next paragraph. Whatever I said thereafter. That the deceased government servant had nominated respondent number 9 as his wife, which implies that the petitioner was not the wife of the deceased government servant. The law with regard to family pension is quite clear, keeping in view the Hindu Marriage Act 1955 and the provisions of Rule 143 of the Assam Services Pension Rules 1969. As per the Hindu Marriage Act 1955 and Rule 143 of the Assam Service Pension Rules 1969, it is the first wife who would be entitled to the payment of family pension, as there cannot be any valid marriage during the subsistence of a second wife for persons professing the Hindu faith. Next paragraph. However, there is a disputed question of fact as to whether the petitioner is the first wife of the deceased government servant, even though the next of kin certificate has been annexed to the writ petition. It is agreed to by the party, the counsels for the parties, that the issue with regard to whether the petitioner or the respondent number 5 may be respondent number 9 is the first wife of the deceased government servant may be decided by whom?
The respondent number 4, Lordship.
By the respondent number 4.
Lordship.
Full stop. Accordingly, the respondent number 4 is directed to cause an inquiry and
Personal hearing also.
personal hearing of the petitioner and the respondent number 5 prior to taking a decision as to whether the petitioner or the respondent number 9 is the first wife of the deceased, is the existing valid wife of the deceased government servant at the time of his death. Full stop. The respondent number 4 may also require the parties herein to submit their Aadhaar cards for verification. Full stop. In the event the applicant, in the event the parties are agreed with the decision of the respondent number 4, they can always take recourse to the civil court to prove whether the petitioner or the respondent number 9 is the existing valid wife of the deceased government servant.
Sometime can.
The respondent number 5 should take a decision on the above dispute between the parties with expeditiously as possible and preferably within a period of
2 months.
2 months from the date of receipt of a certified copy of this order. The writ petition is accordingly disposed.
And that interim order is also there, Lordship. That
Interim order shall continue till a decision is taken by the respondent.
If I am found to be valid first wife, my lord, immediately arrear ballot shall be released, my lord.
That will come automatically.
they will verify.
Obliged.
Item number 48 to 59.
Yes, Mr. Nair.
One case being from 17/11/2023. I may suspect of it. I would also like to take one order passed in this petition.
Same, already ordered.
One is item number 58 and another is 59.
Okay, subject to.
It's already.
This to which post?
Tomorrow also it will be additional.
Huh?
Additional.
Addition chief engineer. Okay, let that addition chief engineer, he's not interested. I think.
In which? Well, additional chief engineer, I was due. I'm definitely interested because I was denied. Well, this is the modus operandi. They always say
No.
that subject to and they start promoting.
Order is it's.
Well, the earlier order, there cannot be an objection when the earlier order says that till the matter is decided. No, if the matter is decided next week, no point. The fact that your lordship is has some difficulty and is fixing up on the 14th during the interregnum period, can I not ask for an extension of the earlier order?
This is the.
Well, why are they so
What earlier order?
The Honorable Justice J.
No,
Jamil-
that is a different thing. That
No,
is
Madam, that is the same thing because what has happened on the last occasion, there were 4 missed cases filed.
In fact, these orders should have been placed by my learned friend.
Which order?
Sorry.
This order was the first order
My
placed.
friend should have.
Yes, in 2021, I was never a fortune teller to know that promotions will be affected when my case is pending.
These are all.
And
So your next promotional post is additional chief.
additional chief engineer. And in fact, Lordship Honorable Justice Jamil rightly has held it that since you are not promoting anyone, the fact that the entire, my lord, let me make my submission, my lord. My lord, he need not be that overzealous. But the
This
problem,
order was not placed before learned justice Jamil Lordship when that order was.
my lord, this order need not be placed because it's a part of the record.
Lordship, in fact, Lordship, in all the cases where the 2023 notification is about and Lordship, same order has been passed.
In all cases.
All cases, Lord.
Because our case is not on 2023. 2023 is only 2 cases. He need not mix up. Well, I'm very clear about my case. We are on the 16 OM, which is no way connected with 2023 OM. I say that the 16 OM's matter is decided by the division bench. You never go on appeal and you implement the order or you.
But the
say-
16 OM does not support you.
My lord,
I mean, the observation
my
made in
lord,
para
on the date
45
of
does
hearing,
not
when your
support you.
lordship will hear, I'll satisfy your lordship, it supports me.
But as on date, it does not,
No, the learned single judge has upheld the Bhagwan Patta's judgment because the operative part of the Bhagwan Patta's judgment is very clear. The benefit of merit cannot be denied till the 1978 Act is in existence. That the division bench has not interfered. Because the division bench knows that if they interfere, the entire reservation policy in Assam will collapse. Mala, the Assam government basically wants to give benefit to a class and they have landed themselves into trouble because our case is there. So what I pray, Mala, I'm not asking for something illogical. The earlier order be extended till the time the matter is. And if the matter is fixed next week also, I'm ready. This is an interim protection which I can always ask, harping on my earlier order. That's my submission.
You don't issue the promotion order.
Yes.
That's all. To the
Subject
next
to
day.
leave.
That first order is already there, Lordship. What we are doing now, only following the first order.
No, but then there is this other order of this.
Then Lordship will see the I, what he has filed. Lordship will kindly see that.
Because you see, this order of the single bench is of 1st March. Now you could have brought to the notice of Justice Jamir this order of 1st March when this order was passed in November.
Because Lordship, at that time on last day, Lordship, this order could not be placed. So many cases were there. And it was in fact, Lordship, I honestly submit, Lordship, my learned friends could have placed that order.
Malad,
This order.
Which order?
First order.
Malad,
But it is your duty also. Why should it be only his onus?
I apologize for that, Lordship. I forgot about that order.
and another thing which my learned friend has not said.
We are in the I, Lordship.
Malad, learned friend has not distinguished one thing. My entire case is on the 16 OM They should not confuse with 2023 because the government stand is you will not be given the benefit of clause 4. The government of Assam in the Rabhas case and Panging case never said you will not be given the benefit of 2023. If the government of Assam has not filed an affidavit to the effect, so the submission of my learned counsel now to say that it will be provisional does not make any sense because my clients are not promoted in terms of 2023 OM. My clients are promoted in terms of the earlier OM, which is reflected in their affidavit in reply, affidavit in opposition.
Yes, Mr.
If this forum said so.
My lord, how one will come into the zone of consideration by virtue of the gradation list? Now, gradation list is depend upon which OM is applicable. Now, if it is 16 OM, they are not. They are within the zone of consideration. If it is 18 OM, they are not within the zone of consideration. So, what is their case? On merit, what is their case? Am I clear to lordships, my lord? First of all, you have to be in the zone of consideration. If you are in the zone of consideration, they will be considered. Now we are at the very first stage. In order to come to the zone of consideration, there has to be a gradation list. Now, issue is while preparing the gradation list, which OM will be applicable. Now, if we take 2016 OM, then clause 4 says they cannot be considered for general category 4. So, my lord, under what law? That's why.
What about this 2014 OM? Is it got?
No, 2014 OM, my learned friend says it has got nothing to do with this. Therefore, I'm not making many argument. He says, so therefore, yes, I mean, help me in a sense, my lord. He says it is not at all applicable. So I'm not making any submission. So therefore, why are you, my lord, promotion is a right to be considered for promotion is a right. Tomorrow, if your lordship finds that he has merit in his case, lordship will directly review DPC. He will not suffer any prejudice. But by granting a stay order, withholding somebody's promotion, and tomorrow if the writ petition is dismissed, then serious prejudice will be caused to the other side. Why lordship will undertake that, my lord? Lordship will not undertake that. As has been observed already in all, not only in this case, my lord, there are so many other cases. In each and every case, my lord, learned friend appear, where the order is, if any promotion is made, that will be subject to the outcome of the case. Now issue is, it boils down to, my lord, consequential seniority. Now, in Bhagavan Patar's case, the learned single just said that it is for the authority, it is for the government, because as has been said by the Supreme Court in my lord Nagaraj's case, 16(4)(a) is an enabling provision. I'm just reading one passage, my lord, with your lordship's kind permission. GLR. Okay. If your lordship would kindly come to paragraph 7, Roman 9, my lord. Paragraph 7, Roman 9.
Yes.
Article 16(4)(a) and 16(4)(b) being enabling provision.
Just a bit, paragraph?
Paragraph, my lord, 7, numerical 7, and the Roman 9, subpara. These are numbered in that way, my lord. Actually, I am holding GLR. Can I find out for a lordship, my lord?
No, 7, 9.
Roman 9.
I don't have 7, 9.
No, it should be there, my lord. In the original judgment, it is shown. I'll find out. Oh, here it is 6.
Okay.
The difference. My lord will kindly have Roman 9, my lord. Article 16(4)(a) and 16(4)(b) being enabling provision, the state is at liberty to implement its policy of giving reservation in promotion with consequential seniority, comma, at liberty to provide for reservation in promotion without consequential seniority or at liberty not to provide any reservation in proportion. As a lordship got it.
Yes.
So therefore, my lord, state, having taken a cue from this observation of the learned single judge, has stick to only reservation in promotion, but no consequential seniority. So therefore, my lord, now what is the case of the other side? Yes, tomorrow if they succeed in establishing that 18,123 or clause 4 of 3816 is bad, they will have a case. In that case, 12(3)(2002 will revive. Otherwise, no. Therefore, my lord, on merit also, I don't think it calls for any interim order. In any case, my lord, since your lordship has fixed the matter on 14, lordship will take a call on that day. And in the meantime, if any promotion is made, that will be subject to the outcome of the case. That is my humble submission.
What is have we made any order in this case? No.
No.
Huh? Just said that. So this part will have to be added.
Yes. Only one clarification, one reply I'd like to make. My learned friend has just now read Roman 8:9. If I may further read, because he left out a very important part. Article 16.4 and 16.4b. It's expected that he should read the entire.
I'll read for my learned friend's satisfaction, my lord. I'll read.
Now he cannot read. I will have to do my
Okay.
reply. Now he cannot read. Article 16.4 and 16.4b being enabled, the state is at liberty to implement.
Wait. I have got to again find yes.
Can I read?
Yes.
Article 16.4a and 16.4b being enabling provisions, the state is at liberty to implement its policy of giving reservation in promotion with consequential seniority, comma, at liberty to provide for reservation in promotion without consequential seniority, or at liberty not to provide any reservation in promotion, full stop. I'll read the final part. However, while implementing, adopting, changing such policy, due process of law need to be followed, including the dicta of Nagraj and Journal. And what is the dicta of Journal and Nagraj? It upheld Article 16.4a, whereby accelerated promotion gives the benefit of consequential seniority. And this was my argument, which has been accepted. And in paragraph 36 of I.V. Gohai's judgment, the argument of my learned friend has been rejected on this point. In the single bench's order, the same argument was made that with the coming of the 2014 OM and being an enabling provision, you don't have right. We have right, which is supported by Nagraj and Journal.
Anyway, right.
Only I wanted the earlier order should continue since in the meantime, they might come up with more mischief, the government.
Right, Mr. P. Nayak, with regard to the interim prayer made by the petitioners council. For restraining any promotion to be made in the PWD and Water Resource Department.
And the civil service, Lordship 3.
And
Assam Civil Service.
And Assam Civil Service, Mr. P. Nayak submits that DPC is to be held tomorrow for filling up the post of additional chief engineer in the PWD. Considering the above, this court directs that any promotion made will be subject to further orders of this court, which would include a review DPC system. However, the above order is subject to is only with regard to the DPC that is to be held tomorrow for the post of additional chief engineer PWD system. However, no further promotion no further promotion process is being contemplated by the government in respect of the other departments, the state respondent should not undertake any promotion process till the next.
My lord,
Obliged.
that will create problem, my lord.
This is only one.
No, no, my lord, since your lordship will maintain an uniformity, right from day one, nobody has passed this order, my lord. From day one, this prayer has been made by my learned friend for quite some time.
Because from
Now, if-
day one, no IA was there.
No, just a
IA
minute,
was
just
there
a
now.
minute. Just let him continue.
Yes, yes, my lord, he is for the primary response.
My lord, lordship will maintain an uniformity. Lordship will not pass an interim order. Lordship, in my humble submission, my learned friend has not made out any prima facie case which calls for an interim. No, my submission.
No, I understand. No, he has not.
My lord, whether there is in contemplation or not, their standing order as on date today is not standing order, rather the interim order, which is, operating in respect of all the cases is, if any promotion is made, that will be subject to the outcome of the case. If not tomorrow, maybe next week, my lord, there could be another DPC where our candidates will appear, my lord. So if their lordship withhold promotion, lordship normally will not direct stay of a promotion. As I have already said, because if you win the case, you get back everything. Otherwise, staying if his petition is dismissed, then my lord, serious prejudice.
That is also.
Therefore, I am saying, my lord. I don't think anything. Tomorrow, if there is any contemplation, let him come. Lordship and give the liberty. Then Lordship will consider.
But I have already come, my lord. He need not worry about my contemplation. The fact that I am contemplating and suffering, I have filed I.
No, but your case is only with regard to additional C.
And
no, my lord, all the three, I have filed 4 IA, and basing on my submission on that day, Honorable Justice Jamir had passed. I don't access permanent. I know my limitation. I ask it because they are not prepared with the case till that day.
Engineer.
Till that day.
IA is for superintending engineer.
It's not for.
No, a direction shall not be issued.
Superintendent engineer and above, because
Kindly see, my lord.
my apprehension is that they might move upward because they have done.
Okay,
But this order remain, lordship,
No,
till
cut
14.
that last part.
Then your lordship will dismiss my IA because at least I
That
can.
I will do what I want.
Yes. Because I have to.
I will do what I want. You
No,
do what you
lordship
want.
has passed an order, and after it is
Look,
the submission of.
no,
I fail to understand when the government advocate has said there are no move to promote other departments.
So
Lordship
I
has
will,
from the
I will,
submission-
I will mold the order as I see
My
fit.
lord.
Yes, sir, I know.
Till I sign it, I can always
No,
make.
that prerogative I'm not, but the lordship will see that I am only asking for an extension of the earlier order. Because your lordship will now have to give reasons to reject my prayer because the earlier orders remains.
I have not rejected. Where is the rejection?
No, your lordship had indicated that the last part won't be there.
Yes.
Deeply obliged.
Lordship will fix it on,
14.
can it be on 12? That I can ask because 12 is a hearing date.
14
Because
also
once
is a
it-
hearing. Huh?
Okay, can it be on 12, lordship? No problem. We want a disposal of the case. There cannot be any two thought on that because everyone is suffering. Lordship will appreciate that part.
Huh?
12.
Have we fixed any cases on 12? Sure. Okay, 12.
No obliged.
All of them. Put all this. Yes, next.
I'm being item number 16, 153.
What is the, who took the dictation? This one?
Lordship, my lord has not given any dictation. My lord has
No
posted
dictation.
query to- There is a query, lordship.
Where are the notes I made?
Engagement of half pay leave. Good health reward is not admissible under rule 22(2).
Yes, yes.
And I get the rule 22(2).
Yes, yes.
And according to this, the facility will not be available in case of separation due to disciplinary action.
Huh.
60 years.
That is for 22(2).
Yes, Lord.
And with regard to
Page number 78. Lord.
and what about earned leave encashment?
Is admissible only if the employee is compulsorily retired as measure of punishment under CDA rules, but earned leave encashment is not payable in case of removal.
Where is that? Where is the rule?
Dismissal.
Where is the rule?
Lots of CDA rule.
Show me the CDA rule. Show me that also. Rule 22. What he was reading?
Rule 22.
I had written some notes of him. I'll tell you. Yes. Where is the CDA rule for earned leave encashment? Okay. That's
I wanted to also see that since they have released my CPF, whether that particular conduct rules, because I have not been provided with a copy. Whether
that
that
you look.
whether it denies CPF or not. If they have, if it does so, they have done the opposite matter. They have released my CPF.
That 22 years delay, Lordship. After 22 years,
No. From
What
the
is your
records,
prayer? What is your to release all retirement? What is your retirement benefits? You do not know.
well, I do not have
What is
access
CPF?
to all these documents like
What
that.
is CPF?
CPF.
Where is your? You could have made a RTI application. What prevented you?
CPF, Lordship, they have received the CPF, no? Yes.
So you have received CPF.
I have seen the order of the Supreme Court dismissing my case. And
Huh?
then Lordship has seen the order of the Supreme Court dismissing. Immediately, that is on 2006, I surrendered. In 2007, August, I am released. In the very next year itself, within a period of 1 year, I make an application at page 49, asking for the dues. All this while, my lordship has seen the criminal appeal also. Then I go to the Supreme Court. I serve time. I am released, and then immediately within 1 year, one year's time, at page 49, I filed this application, which is admitted by them in the very next page, page 50, asking for my documents to facilitate release of the CPF account. Not the others, which I have asked by this letter at page 47. Now at page 49, my lord, I asked for all, my lord, to see, you have placed me under suspension with effect from 86. I am entitled to subsistence allowance from period so and so. When you dismiss me, I have CPF against account number so and so and leave salary.
Where page? Where have
49,
you?
my
Huh?
Page 49.
Page 49, huh?
Yes.
Yes.
You have placed me under suspension with effect from so and so. I am entitled to subsistence allowance from period so and so to so and so.
What you are entitled to?
Subsistence allowance.
Why?
Because I was placed under suspension, my lord, before my dismissal. Now that also remains. Then the very next para,
From which period were you placed under suspension?
my lord, 2012-86 to 19/5/1990.
Where have you stated? 2012-86 to 19/5/1990.
Yes. Then in the very next para, your lordship will see, I have CPF against account number so and so and leave salary not encashed till my suspension. All the above dues may please be released in favor of me immediately. On the very next page, page 50. Again, another letter from me to them in which it is stated that there was a communication from ONGC to me after my first representation. The very first para refers to that particular memo. Page 50.
You were dismissed when?
1999.
1999. And
Yes.
you have come to this court when?
My lord, I asked for these retired benefits from 2020 onward. But
When did you come
I
to this
placed
court?
my case before the ONGC authorities since the time when I was released from prison.
No, you said that CPF has been given.
Yes,
Then?
at page 52, my lord. Sorry, my lord, at page 53. After my representations asking for these benefits, they released the CPF, leaving all behind. Page 53, this is the CPF one which they have released.
When?
This is
2010.
Yes, ma'am. 2010. That shows admission. Now, my lord, I can place an order of the judgment of the Supreme Court which says that if I assert my right within the time prescribed by law, then whatever whatever action they do not take, that is a recurring one.
But
My
this is-
right accrues, my lord.
Correct, but then this is what is the time limit prescribed by law?
My lord, I understand that as per the Limitation Act, my lord, 3 years will apply. But I placed my case before them immediately after I was released from prison, and lordship will see that they are.
When were you released
I
from
was sleeping, my lord.
when were you released from prison?
I was released from prison in the year 2007,
Then,
August.
then when have you come to this court for asking for this?
My lord,
Just now you said that that the Supreme Court has allowed a person
My lord,
to apply for benefit.
My lord, they allow me to place one judgment. Why I'm saying that my right accrues because it's a recurring one. Because
Recurring
I
one?
raised
What
my-
is
I have to raise
recurring?
my grievance within the time period of 3 years. My lord, I did so. They admitted because they paid the CPF amount. Once they admitted, my lord, my right accrues because it becomes a recurring one. Even though if I don't raise it before this court within the 3 years period.
It's not like a pension or a monthly pension. It's not a
My lord,
recurring.
this
Those
is-
are recurring.
my
A
lord, these are retired benefits,
one
my
time
lord.
payment is never a recurring.
My lord would kindly appreciate, my lord, that these are components which were deducted from my salary. And they are with them, my lord.
So now you have the only thing is that subsistence allowance.
Substance and allowance, my lord.
Yes, was he given subsistence allowance?
They are silent regarding this para. They are silent.
But according to the instruction of ONGC, you will not get anything, Lordship.
Why? Subsistence allowance. When was he suspended? Was he suspended? But yes, 22 years is too long a time.
No, Lordship, 22 years after.
Right.
My lord, I have placed the query before him, my lord.
That's
He
22
himself has
years too
admitted
long.
that he has not passed any executive order, my lord.
22 years
Only
from the
in this
dismissal of
particular case
service
they come
and 22 years from the dismissal of his service and after 15 years even from his release from the jail in August 2007 and after 8 years from the judgment dated 5/9/2014.
That is the time period he is specifying on me filing this case, my lord. But I have raised my grievance and they have admitted also in paying the CPF.
Lordship, he was our employee, so CPF is.
Exactly, these components were deducted
Yeah,
from my
then
salary.
what about paying back what you have stolen?
But I'm willing to pay back, my lord. 2,20,000. Let them calculate. I'm only praying for that particular mandamus, my lord, nothing else. Let them calculate if they find that I'm
Okay, right. Heard Mr. P. Bhardwaj, learned counsel for the petitioner.
Yes.
Also heard Mr.
A. Hussain.
A.
A. Hussain.
A.
Hussain.
Hussain, learned counsel for
ONGC.
the ONGC. Hussain.
Respondent number 1, 2, and 3. And in read petition number 1417 and respondent number 1 and 2 for read petition 1595.
The two writ petitions are being disposed of by a common order. Inasmuch as the petitioner in WPC number 1595 of 2020 has paid for release of gratuity for his service from the date of his joining the post of
My lord, this is assistant grade 2.
assistant grade 2 in the ONGC on 28/2/1973 to the date of his dismissal on 19/5/1999. Full stop. In WPC 141722, the petitioner has prayed for release of all retirement benefits which the petitioner is entitled to without specifying which retirement benefits he is entitled to. He is entitled. Next paragraph. The petitioner's case is that he was appointed as an assistant grade officer, assistant grade 2 officer in the ONGC Limited on 28/2/1973 and was dismissed from service on 19/5/1999 on being convicted as the petitioner was convicted in a criminal proceeding on corruption charges for having misappropriated rupees 2,20,000. The petitioner was convicted by the Special Judge Prevention of Corruption Act, Guwahati, in special case number 1 bracket C of 1988 by judgment dated 24/9/1996 and his appeal in this court by criminal appeal number 266 of 1996 was dismissed on 28/4/2006. Next paragraph. The petitioner had also put to challenge his order of the impugned order dated 19/5/99 by which he had been dismissed from service in WPC number 1965/2007, which was however, WPC number 1965 of 2007 was dismissed. While order dated
5/9/2014.
5/9/2014. Next para. The petitioner claimed payment of his CPF amount. What is CPF? Full form?
It's contributory provident fund.
Contributory Provident Fund, bracket CPF. On being released from prison. And the petitioner was paid his CPF on 21/9/2010. Acha, dismissal of WPC is 5/9/2014. We have written that, no? The petitioner's counsel submits that the petitioner is not aware of the benefits that would have to be paid to him by the ONGC. And it is the duty of the ONGC to clarify as to what should be paid to the petition. Next paragraph. Mr. So-and-so, learned counsel for the ONGC, on the other hand, submits that the writ petition for payment of service benefits having been filed 22 years after his dismissal from service, the same is hit by delay in latches. He also submits that
And almost 8 years from the date of judgment.
he also submits that the
8 years.
present writ petitions. No, there's one is at 2020 also. Where is that para?
Para 68. Reply 1417 of 2022, page number 68.
No. Those answers that you gave regarding the various payments.
Para 18, my lord, of the affidavit.
Also submits that. As a consequence of the petitioner being dismissed from service, which is a major penalty, the petitioner is not entitled to payment of gratuity, as gratuity is forfeited on on grounds of dismissal. Further, encashment of half pay leave, bracket, good health reward, bracket close. Sir, this is at page 78. Is not admissible under Rule 22, bracket 2 of the leave rules, 1995. Earned leave encashment is also not payable in case of removal and dismissal from service. He also submits that the petitioner is not entitled to any post-retirement medical benefits or traveling allowance as he has been dismissed from service. Asha, what about this page 77? You have said relevant provisions governing the issue of terminal dues are covered by clause 9 of the schedule. Where is this? Have you got it, Mr.? This page 77.
77, not sure.
Where is that? Clause 9 of the schedule. Where is this clause 9 of the schedule? He accordingly submits that the writ petition should be dismissed. I have heard the nurse counsel for the party. As can be seen from the leave rules, from the Oil and Natural Gas Corporation Limited leave rules, 1995. Hereinafter referred to as the leave rules. The petitioner is not entitled to encashment of half pay leave or leave encashment as he has been removed, as he has been dismissed from service. Further, where is this gratuity? Regarding gratuity, where is it? Further, in terms of Section 4, bracket 6 of the Payment of Gratuity Act 1972. Gratuity, the gratuity payable to an employee may be wholly or partially forfeited if the services of such employee have been terminated for any act which constitutes an offense involving moral turpitude. In the present case, the petitioner has been convicted for misappropriation by the learned trial court, by the learned special court, Prevention of Corruption Act, and Prevention of Corruption Act, and the same was upheld by this court. Before appeal, in respect of the charges under section 120B/468/471/420 IPC, read with and under section 5 bracket 2, read with section 5 bracket 1 bracket D of the Prevention of Corruption Act, 1988. So the same was upheld by this court. On considering the fact that the petitioner is not entitled to any payment of gratuity as he has been convicted for moral turpitude, and as he is not entitled to any other areas besides CPF which he has been given. This court is of the view that this court is of the view that the petitioner would have to bring out specific instances regarding payment, non-payment of subsistence, with non-payment of dues, service dues. Though the petition, what about this thing, subsistence allowance?
Regarding subsistence allowance, according to my inspection, they said that we will not get anything.
Why?
In that case, I have to take inspection from ONGC, not say, one another date.
But then again, with respect to the fact that, with respect to the issue of whether the petitioner had been given subsistence allowance during his suspension period, if any, and during suspension period, and keeping in view the fact that he had misappropriated, 2,20,000, besides the judgment of the division bench of this court passed in Harendra Chandranath versus State of Tripura, reported in 2013, 2 GLT 1094, having provided that there can be no claim for arrears of money beyond 3 years prior to the date of institution of a writ petition. This court is of the view that no case for claiming any service benefits has been made out. In view of the reasons stated above, and in view of the fact that there is a delay of more than 22 years in filing the present writ petition, the writ petition is dismissed for delay in laches out. Writ petition is not as of.
I understand your lordship is rising for another.
Yes, what is that?
The item number 74 to 81, there is a series. That may be fixed on 7th of December. I have spoken to all the other councils.
I appeal for the petition. Item 74 to
81.
Okay, right, on the parties list the matter on 7th December.
Lordship, can it be a week, the week next, Lordship?
Huh?
There's some difficulty on our part.
When do you want?
The week after, Lordship, maybe on 12, 13, Lordship.
12th, we've already fixed that.
13, Lordship. 13,
13th is the motion day.
14, Lordship, Thursday, Lordship. 14. Sorry,
I have some difficulty. Which item we want?
Same series. Same series.
Oh, I don't know, you all decide.
19th,
76.
In that case, let it be 19th, my lord. Apparently, Mr. Kane Chaudhary is not available on that date.
Okay, this is the matter on 19th. It will be the last week, by the way.
That will be the last week. Let it be. That is January. Huh? 5th, I am not available.
12th. This is the matter. Huh?
12th.
No, 12th of January, they are saying.
December.
December, we've already fixed that Mr. D.K. Das and Mr. Chaudhary will take the whole day.
Oh, that reservation matter.
Reservation matter. I doubt it will be completed on that day also.
19th of In that case, my lord, let it. Okay, 14th. 14th.
Actually, I'm traveling, so I'm requesting for January.
We'll inform the date.
We'll inform you. We'll have a consensus, my lord. There are several councils involved.
Leave the matter on dash.
Item number 66. Now it's a very small matter. Lordship, can it fix it on next 23rd matter? Just they need to produce the file, my lord, about that withdrawal of suspension order. 23rd.
Okay, this is the matter on 23rd.
66.
Item number 69, my lord.
Yes, 69, yes.
Lordship, 69 on any date, my lord, on 28 or 29.
Okay, this is the matter 28.
Date is Lordship.
28, no.
Uh,
28, 28, I won't be here. And 29, I can be. Okay. You give a date.
30. Wait, Lordship, item 84 from the batch of 83 onwards. Lordship, this is interim order operating. Lordship, please be extend the interim order.
Okay, in that batch matters, 83 onwards. You just say any interim orders passed in any of the cases shall continue till the next date.
Obliged.
Can it be on the 14th of December?
72, my lord.
72.
72, my lord. Any date, my lord, permit lawsuit.
72.
My lord, say an amendment matter, my lord, my friend has no objection actually.
Where is that review petition in that, your case was restored on the basis of a review petition?
My lord, my lord.
Lordship, the series matter, Lordship, can it be on the 14th of December, Lordship, 83 to 96?
Mr. Counsel, you all have a discussion. I do
Lordship,
not know,
we'll
because
inform
Mr. Indanil was saying that.
that's a different,
The other batch.
this is the other batch.
Which batch?
Item
83 to
86.
96.
Very
83 to
simple.
Acha,
96.
you all are 83 to 96.
On 14th of December, Lord.
Okay.
No, apply, Lord.
I got. We don't know if we'll be able to do so many cases. Yes, anyway.
Any date, my lord.
Okay, in item 72, you write. A registry to list this case,
Any date, permit your lordship.
give a date. December. Along with the disposed of a review petition number 81 of 2019.
25.
I seek your lordship.
Your case is basically you are removed by the managing committee.
My lord.
Correct?
Yes.
Whether this case is maintainable.
Yes, my lord. Yes, my lord. And my lord, actually.
There is a judgment of Justice B.K. Sharma, I think against you. We'll find out.
My lord, I have find some judgment in my favor also, my lord. I'll place that also, my lord.
Okay.
24.
I seek your lordship in respect of item number 67 and 68.
Yes.
Your lordship, perhaps recall these disability matters. Your lordship had fixed the matters for the wife who has approached the honorable court for her husband had acquired a disability during his services.
Okay.
These are fixed matters and any date next week, your lordships. Tuesday, Thursday, subject to your lordship. They were required to just get instructions and make the interim payment to me, your lordship.
Not done.
Not
You were
not-
supposed to give some guardianship certificate.
I had placed it right here before your lordships in the court. And then next day itself, I went and gave it to the authorities. Then in the interim, the matter again came up before Justice Jamil, who also directed them to make the interim payment. It was fixed today, your lordship. Since it couldn't
Why
be
don't you
taken
file
up.
a contempt then?
It's the contempt, the lordship, there's already an order, an earlier order, but in a dispose of a petition, a contempt petition is already filed against them, your lordships. They're not doing anything about it. Lordship, I am at your lordship's mercy. Next week, your lordship, let them get, maybe perhaps they might make the payment in the meanwhile.
You give them? List the matter on, give a date.
20, huh? Keep it, 24. Deeply obliged, I'm deeply obliged.
That if we having such that outline, see what is the case of the petitioner and how did London Civil Judge answered whether those findings are tenable in law. They are answered the whole matter. They are answered the whole matter. There is no occasion, any reason to go anywhere else than the pleaded case because this is the plead petition. They have alleged their ground, their grievance on the first point. Lordship will kindly note it. Lordship has noted it earlier also. The first point that I could not have been considered and appointed as the secretary to the Honorable Chief Justice, either in the capacity as workers or subsequent finalization, regularization, workers, yes, officiating, sorry, officiating capacity or then regularization. In both these occasions, they are agreed And that's why they have filed these two sets of writ. Challenging the first officiating appointment and then the regularization appointment. This is the basic crux. And then Lordship will find. What is their contention? Their basic contention is that my appointment to the post of protocol officer, which is the feeder cadre for the post of Secretary to the Chief Justice. My appointment to that feeder cadre post of protocol officer is temporary. Therefore, I do not and did not come into the zone of consideration for.
Not because more than the temporary part, but because your seniority would be counted
in the lower category.
In the lower category.
That is what their contention is based on that condition. They say that it would not have been considered to be a substantive appointment because he was appointed with the rider that he will maintain his seniority in the lower category. Therefore, it should be considered to be a temporary appointment only, and therefore he could not have been considered for the post of Secretary to the Chief Justice, even for appointment as in officiating capacity. No question of subsequent regularization. This is the outline. This is the outline. They have not put any challenge to any rule. It is not the case of the writ petitioner that certain rules have been violated or that the procedure followed was totally irrational, illegal, unfair, and as such, we were not considered and the whole process has been vitiated. This is not the case. This is not the case. That being the position, now what is to be seen? How the learned single judge has considered the entire matter? The learned single judge has considered the matter, taking it as a promotion to the post of protocol officer. Firstly, the learned single judge has considered it to be a promotional post to the post of protocol officer. And that is only temporary because that particular rider that he will maintain his seniority in the.
No, you have been promoted to protocol officer.
Well, this is a direct appointment, not a promotion simpliciter.
A protocol officer is equivalent to AOJ. Is it?
AOJ. So it is a higher post, higher grade, but
your promotion has not been regularized.
No, it is not a promotion as such. It was a direct recruitment in-house. It was done by an advertisement
Calling for options.
Asking for options from all those candidates who are in the senior judicial assistant cadre as per the rules. And those who have given their options, amongst them, there was a selection process. And out of that selection process, one was selected, and that is this respondent. And he was appointed. While making the appointment, that rider was mentioned that he will maintain his seniority in the lower cadre, because this is the original his cadre, wherefrom he has jumped to the post of protocol officer. It is in the higher grade. Now, the question is, therefore, the legal question, pure and simple, whether that clause, that particular condition mentioned in the appointment letter as protocol officer will have any bearing to construe it as a temporary appointment, or it has to be ignored in law and he gets the benefit of a substantive appointment in that post of protocol officer. That is the crucial point. If that is cleansed, the rest will follow automatically.
Correct.
So my response submission is how to decide whether a particular appointment is substantive or it is temporary.
Yes.
The yardsticks to be followed, considerations which
are required to be pondered upon to come to a conclusion in either side is to be seen first. What is the nature of the post? Number one. Whether the post is temporarily created, whether it is a permanent post, first thing. And then how the post was filled up. How the post was filled up. What is the process followed? And then when the person was appointed after that process of selection, whether he was appointed with full financial benefit of that particular post, which the particular post carries. And lastly, what duty did he perform? What duty did he perform in that post? What kind of duty? Whether he performed entire duties of the post of protocol officer, or he was entrusted with some partial duties as a stopgap arrangement. Now, on this plank, if we consider the appointment of this appellant, Lordship will find the post is a permanent post. It is in a permanent cadre at the service of the High Court. And the process of selection was followed. There was an advertisement asking for options. That was the process which was followed at that particular point of time. That process has been laid down by the appointing committee of the judges of this honorable court. Therefore, options were asked for. Those who could have applied for, those who could have opted for. From amongst them, some of them opted for. Definitely not all. Not all. But some did, including this appellant. And there was a selection from amongst them. It is not the case of the petitioner side that no, there could not have been the option, calling for options. They did not challenge it. They didn't challenge it. There was no challenge made to the appointment of the protocol officer of this appellant. That stood admitted that yes, he was appointed. Only thing is, because of this rider, that he will maintain seniority in his lower cadre, it makes the entire appointment temporary. Whether that is sustainable. Whether that is sustainable. Now, so then the advertisement was there, options were asked for. Those who are interested, they have given their options. They know, my lord. Those who have applied, they also know that once selected, they go to a different post with higher grade, higher pay scale, and everything different, with some duties, more responsibilities. That also they know. And those who did not apply for, they also know that they are going to miss this opportunity. They will not go to the higher grade. They will have to remain in their grade, waiting for their due promotion in due time. That is the option. Therefore, they have applied and selection was made. Selection was made by the selection committee, and that was finally approved by the Honorable Chief Justice, and this appellant was appointed. The learned single judge says that requirement of qualification there also is a law degree, which is not correct. Am I correct?
In protocol officer.
In protocol officer? Yes.
Paragraph 26, page 170.
Kindly come to that part.
Read table 5.
Read table 5, Lordship will take up.
Page 7.
Page 7. Paragraph 23.
Paragraph 26.
This Lordship, we have this paper book, my lord.
Lordship,
this paper book, my lord. We have given one.
Yes, that one.
That here, my lord, we have indicated Lordship and noted there itself. It will make it easier. Page 7. It's important. Page 170, paragraph 26.
Page 7, from beginning, my lord, we'll see page 7, not the judgments.
Running
Yes,
page
page
7.
7. Yes.
Running page. We have given the note here. That I will take your lordship. The learned Chingal just relied upon the paragraph 20 of the Rudra saying
No,
judgment.
no, wait. Page 7.
Page 7. Running page 7 of
Is the judgment.
No, not
No,
the
no, no.
judgment. Page, here it is, my lord. From first page, it is page 1.
Okay.
of this paper book.
Paper book.
We have given
Okay,
it a
okay,
note.
yes.
Yes. This, well,
In the
important,
midst of the page.
Yes, yes.
yes. But this is, your lordship will find at page 170 of paragraph 26 of the judgment. I will take your lordship to this, but we have indicated what? The learned Singulitas relied upon the paragraph 20 of the Rudra saying judgment to hold what is ad hoc and what is substantive appointment. But the learned Singulitas most surprisingly and mistakenly held that the requisite qualification for protocol officer was LLB degree, whereas the LLB degree was a requisite qualification for the post of secretary to the CJ, which however can be relaxed by the Honorable CJ in an appropriate case. This is our case. Admittedly,
No, okay, CG can relax.
yes,
CG can relax.
but not
But
for
the issue is, one of the issue is that condition, why did the, why was that condition placed? That his seniority would be counted from the
Yes.
lower cadre.
Yes.
That
Well,
is the one, that is the thing that is really
troubling,
bothering you.
troubling us.
Yes.
Yes, my lord, my full submission would be to resolve this issue, that particular point, we will have to fall back on the principles laid down by the apex court, followed by this honorable court, as to how a particular appointment shall be construed, either to be a substantive or ad hoc or temporary. We need not have to go into other things. That will cleanse the whole issue. Firstly, my lord, what I say is, I am referring to this particular paragraph in the paragraph, page 170 of paragraph 26 of the impugned judgment. Lordship may turn to that page 170. In the appeal, my lord, lordship will find.
Appeal memo.
Appeal memo. Paragraph 20.
Page 170.
Yep. Milan.
Yeah, properly. Page 178.
Yes. Yes. Now,
Yeah,
lordship will kindly from 170, lordship will go to page 170, paragraph 26.
170 appeal memo. Appeal number 5.
Appeal memo?
Memo.
Not
this paper. But lordship will for the time being keep it aside.
$170.
Yes, 170.
Yes.
My lord, I will read from paragraph 26, top of the page. In the case of Rudra Kumar Singh, it has been laid down that to hold an appointment to be substantive in nature, though made as a stopgap arrangement, the person should possess the requisite qualification. For ready reference, paragraph 20 of the judgment is extracted herein below. That 20. In the service jurisprudence, a person who possesses the requisite qualification for being appointed to a particular post, and then he is appointed with the approval and consultation of the appropriate authority, and continues in the post for a fairly long period, then such appointment cannot be held to be stopgap or fortuitous or purely ad hoc. Yes, so also I rely. This is the principle laid down. Now, it is seen that the essential requirement is to possess the requisite qualification, which in the present is the degree of LLB. But this is only relevant to secretary, post of secretary, not for the post of protocol officer.
But how do we know that this paragraph is relatable to protocol officer?
So let us read further. But let us read further. In the case of K. Solendro Moses, The Telangana High Court followed the law laid down by the Honorable Supreme Court in the case of O.S. Singh and R.K. Singh. In his reply, Sri Patwari Learned Counsel for the petitioner submits that though the rules holding the field give power to the Honorable CJ to relax the qualification and criteria, he submits that such power needs to be exercised in a reasonable manner and only to overcome any difficulty or lacuna. The said power cannot be exercised to the prejudice of the other eligible candidates. He submits that the respondent number 5 is not an LLB degree holder, which is an essential consideration, and therefore would not have come to the zone of consideration for promotion to the rank of secretary to the Honorable CJ.
Only because of the to decide the point whether it is substantive or not.
Yes.
There is no dispute that the secretary post was initially appointed on officiating the dispute is on the post of protocol officer.
Yes.
Because
first thing, the appointment of protocol as protocol officer. Then we will come to the court is discussing the points, referring to also the secretary, but kindly go further. Let us see. To appreciate the issue involved, it would be appropriate to refer to the concerned rule governing the appointment of secretary to the Honorable CJ. That is Rule 73A of the Rules 1967. The relevant extract is quoted herein below. The secretary to the Honorable Chief Justice shall be appointed from among the gazetted officers of the High Court services belonging to Class 2AA, Class 2B, or Class 2C, having a degree in law considered suitable by the Chief Justice. Unquote. 30. Any analysis of the rule makes it apparent that the said appointment to the post of secretary to the Honorable CJ can be made on fulfillment of the following ingredients. From gazette officers of the High Court service to such gazette officers should belong to Class 2AA, Class 2B, or Class 2C. The said officer should have a degree in law. This officer has to be considered suitable by the Honorable CJ. The first three ingredients are objective in nature, and only for the fourth ingredient, namely suitability, the element of subjective satisfaction would come in. There is also no dispute that the post of protocol officer belongs to Class 2C. The aforesaid rules are also to be read along with Rule 63A, which gives discretion to the Honorable CJ to relax the qualification for appointment. Rule 63A is quoted here in below. Quoted. The Chief Justice shall have powers to relax age or qualifications for appointment to the service of the High Court in appropriate cases according to his discretion. Unquote. With the aforesaid backdrop of the concerned rules and the interpretation, therefore, thereof by various judicial pronouncements referred above, the records of the case which has been placed in original are required to be examined. The Honorable CJ, with an endorsement dated 4/9/2018, had recommended the name of the respondent number 5, who was a protocol officer in Class 2C, for appointment as the secretary to the Honorable CJ on officiating basis by endorsing the condition in the note that he will maintain seniority in his original cadre of SJA. Consequently, the notification dated 10/9/2018 was issued. The file further reveals that a subsequent exercise was done, which was proposed with a note dated 3/7/2020 on the issue of regularization of the post of secretary to the Honorable CJ. The note also contains an observation that on an earlier occasion, an incumbent was posted to the aforesaid post who did not have a degree in law, and also that absolute discretion be given to the Chief Justice to appoint any suitable person to hold the post. The said note was approved by the Honorable CJ on 4/7/2020. The approval was on the following considerations, which are required to be put on record. This order in reference to prepays. Considering 1, the consistently good work done by Sri Nirut Sharma while attached with various Chief Justices as depicted from his ACR. 2. The efficiency, integrity, punctuality, dedication towards duties without taking break, knowledge of computer applications, thoroughness in performance of all tasks, searching judgments and preparing templates of judgments, quality of interaction with officials within the institution and of other institutions, confidentiality maintained by him, his good and differential behavior with the registrars as observed by me during his assessment as Secretary to the Chief Justice. 3. That Sri Sharma has attended office every single day of my tenure as Chief Justice of Guwahati High Court from 9:30 a.m. or earlier if required till late night. 4. The earlier precedence of Sri Soilendra Chaudhary. 5. Absolute discretion vested with the Chief Justice to appoint suitable person to hold the post of Secretary to the Chief Justice. 6. Powers vested with the Chief Justice under Article 229 of the Constitution of India in this regard. 7. The law laid down by the Honorable Supreme Court of India as referred to in the note put up before me. 8. The fact that Mr. Sharma has been serving on temporary and officiating basis as Secretary to Chief Justice of Guwahati High Court for the last over 2 years, and in case of such sensitive post, ad hocism is not good for managing the administration and administering the Secretariat of the Chief Justice. I hereby, by virtue of powers vested under Article 229 of the Constitution of India, read with Rule 63A of the Guwahati High Court Service Rule 67, exercise my discretion and relax the qualification for appointment to the post of Secretary to the Chief Justice, Guwahati High Court, and regularize the appointment of Sri Nirut Sharma as Secretary to the Chief Justice, Guwahati High Court. This is regarding his regularity. 33. The aforesaid consideration.
One thing, this order.
Yes.
This is relaxation of the qualification.
Yes.
While regularizing it has relaxed.
Yes.
But during officiating, was it relaxed?
No. No. Well, in my response submission, that is why he was not substantively appointed. Because that time, the court, the Honorable Chief Justice didn't consider his case for substantive appointment. He was selected, he was found suitable, but because he was lacking this qualification, law degree. Therefore, initially, he was not appointed in substantive capacity, he was appointed as officiating. So officiating capacity can be made. Officiating capacity, he can be appointed.
Can a person who doesn't have the eligibility criteria be appointed on an officiating capacity?
In my response submission, my lord, this is done. In law, this is not unknown.
No, I want what does the law say?
Any vision to that? The substantive subject always. So, as a temporary appointment. Well, we do not have a decision at this moment on that count, but my response submission would be to appoint a person to hold a post permanently, you will have to fulfill all the requirements. Unless.
So that is what.
Unless it is condoned or relaxed, whatever it may be under the rules.
So because here, while looking at this discretion of the Chief Justice,
yes,
the discretion has been made in respect of the promotion while regularizing the promotion.
Yes.
The question is whether a candidate would require, so that it appears that there was no relaxation of the qualification at the time of officiating promotion. So is it required that a person has all the eligibility criteria at the time of officiating promotion, as no discussion had been exercised.
All right, madam. If that question that has come to your office mind is one aspect, relevant aspect to be considered. But my response submission would be, firstly, as I submitted earlier, and as the track supports, there was no challenge made to that appointment.
To which appointment?
To this officiating.
It has been, officiating has been challenged. Officiating and regularization have been challenged.
No.
That protocol officer has not been challenged.
Protocol officer has been, that is what I'm saying. The protocol officer was not challenged. Then subsequent his promotion or direct appointment, this is an appointment again in the higher group cadre. The secretary, there they have filed the petition on not on this ground. They have taken the ground that he was not qualified.
Qualified for the feeder, he was not from the feeder.
No,
he was not qualified because he was not holding the post substantive. That was not a substantive.
No, but
Or
the question still remains. Can a person who doesn't have the eligibility criteria be promoted on an officiating basis?
By response submission, well, that can be done.
Can be done.
Can be done.
So let us have some rulings on that.
Yes.
Citation on.
We'll have to place it. We'll come up with it. We'll have to start out and we'll place it because there are decisions to my understanding, to my memory. I can remember correctly.
And whether if done,
yes,
if not allowed but still done, is it a curable defect?
Yes. Yes.
Huh?
That was cured. That was here.
No, it was cured. But we'll have to see
whether that can be cured later on.
Whether it can be cured also.
Yes. Well, if it is permissible in law, then this is already.
But that doesn't take away the fact that though there is no challenge to the post of protocol officer, the post of protocol officer, his appointment thereof was not regularized. So it's deemed to be regularized according to you.
Yes, it is already a substantive appointment.
It is already a substantive appointment. There is no need of regularization. It was not an
That is what the High Court has pleaded before this.
It is the pleadings of the High Court.
Maybe.
Yes.
Pleadings of the High Court.
They are the base authority to say whether it was a regular appointment, officiating, or a temporary, whatever. It cannot of taste to determine whether it was a substantive appointment or not. It's been set out in certain authorities, judgment of the Honorable Supreme Court and our High Court.
But what was the need
that is what
of having his seniority counted in a lower cadre?
That is what I am saying, my lord. Our submission all throughout was that this particular condition mentioned in the appointment letter, which is per se the rules, cannot have any bearing.
No, there was no rule.
In a service condition.
There was no rule.
That is what.
If
there was no rules,
and
then it has no bearing.
So one way of looking at it maybe is, since it was done on the basis of the instructions made by the High Court.
Judges Committee.
Actually, by the High Court basically. Committee is High Court.
Yes.
Because that has to be again approved by the Chief Justice.
Yes.
So whether the same can be said to be, an executive. Yes, whether the same could have denied the appellant, or whether it can be said that it was not a substantive appointment just because of that.
Because of
that's a peculiar sequence.
That is why my response submission is Lordship will have to go back to the background facts leading to filling up that particular.
Only thing is that in service jurisprudence, when you promote a person, you don't say that his his seniority will be counted in the grade that he has already left.
Yes.
That hits at the very concept of promotion.
That is why my response submission is, as I have been submitting repeatedly, that this has no consequence at all. Provided, of course, if I would have at a certain point of time reverted back, then only that eventuality, that condition would have helped me. But so long I'm holding the post as a member of that particular service, it is I'm entitled to the entire benefits emanated from that particular post. That might have been so. So, Lordship may also consider that when it says that the post shall be filled up, that instruction, let us take it as an executive instruction of the High Court, will be filled up. Then that will be by inviting options and following a process of selection. Had it been a temporary post, had it been the intention of the authority not to appoint me regularly or only as a temporary appointment, stopgap arrangement, I would not have been granted the scale pay, grade pay of that particular post. I would have been granted little allowances, it may be, for discharging the service in that particular grade, particular post. Something extra allowance could have been given. So therefore, it was not in the instructions also that when he will be appointed with this condition, he will get only allowance, not the grade pay. Not the grade pay. No, not that. Therefore, the logical conclusion that would follow in my respectful submission is, going by the principles, even in Saini's case, as well as in Balasada's case, considering the entire background as to how the post was filled up, what is the duties discharged, whether he was given full benefit of the particular post, it leaves no scope but to say, but to hold that that was substantive effort. It was not a temporary. So long he is holding that post, he is in substantive nature. Fact also remains that the post is a permanent. It is not a temporary. Therefore, in my respectful submission, this particular condition should not detain us anymore to cast a doubt that this will have some impact at all, and my appointment will be rendered temporary. No, in my respectful submission, that conclusion will be not fair and legal. It will be an erroneous conclusion.
It's good for both of us. No? Yes.
So, my respectful submission is the finding of the learned single judge was erroneous on that top. This particular consideration cannot have any legal effect going by the background fact situation in the case and the executive instructions holding the field on that particular day. Therefore, next question is whether I could at all be considered for the post of secretary to the honorable. Then also I will have to refer to my appointment to the post of protocol officer. As I have submitted, if Lordship is satisfied to take it, that my appointment being in substantive in nature, I am holding the post as a member of that particular service. I was a member. Till that, I was a member of that particular cadre. I am a member of that particular service. Protocol officer. So obviously I come within the zone of consideration.
So basically, the question is whether your promotion as protocol officer was a substantive promotion.
Yes.
That's all.
That's all.
And once you can prove that,
right,
then the others, I think, follow naturally. Isn't
Exactly.
it correct, Mr.? Don't worry.
Well, I will take
The question is whether the question is whether the promotion of the appellant to the post of protocol officer was substantive in nature. That's the basic issue, I think.
My lord, that point has been dealt with by the learned senior.
No, but that is the crux of the issue, I think.
My lord, in my humble submission, that protocol, his appointment as a protocol officer has not been interfered with. Okay, you kindly peruse the judgment. There is no interference.
That has not been interfered. But saying that it is temporary.
No, Lordship will kindly. My lord, if he had any demand against his, if suppose as my learned senior colleague says there is a substantive proof. If he had any demands, because the rider attached to it says it is not, he ought to have filed a writ petition and get it corrected, my lord. In my writ petition as an OP, how can he claim release, my lord? And why we did not challenge the protocol officer? Because of the same very reason that it is not a substantive post. It's a temporary officiating capacity. Some regular
Protocol officer is not a substantive post?
Yes, no, but the appointment. I am speaking about the appointment. The appointment was not in permanent capacity, my lord. It is officiating in temporary capacity. So some people who are senior to him may not like to join that post, my lord. And Lordship will kindly come to that interim judgment. I'll just read 2 paragraphs, my lord. Lordship will kindly come to page 175. (175), retaping number 5, my lord.
Yeah.
Para 36.
Yes.
Yes, may I just read it, my lord. Another important factor which intrigues this court is that the initial appointment of respondent number 5 as the secretary to the Honorable Chief Justice on officiating basis by the order dated 4/9/2018 is itself clouded. In this connection, an argument was advanced on behalf of the High Court that since respondent number 5 was in the feeder cadre of protocol officer, there is no illegality in appointing him as the secretary to the Honorable Chief Justice on officiating basis. This argument is not sustainable in view of the settled law that even for appointment on in-charge basis or officiating basis, the qualifications required cannot be done away with, and the procedure laid down in the rules had to be substantially followed. An argument was sought to be advanced by Sri Swayancho, the learned senior counsel for the High Court, that the order of appointment dated 25/11/2016 of the respondent number 5 as protocol officer was substantive in nature, the same very argument which is now sought to be advanced by us. This argument, however, is difficult to be accepted in view of the rider attached to the order dated 25/11/2016, that the respondent number 5 would maintain his seniority in his original cadre as SJ. If the promotion as protocol officer was made on substantive basis, the question of attaching such a rider to the promotion order dated 25/11/2016 would not have arisen. The impugn action also appears to be in consonance with law in view of the riders attached to both the orders dated 25/11/2016 and 10. My lord, if the argument is to be accepted that for protocol officer, the rider has to be ignored, then my lord, why the same rider is also attached to the officiating capacity as the Honorable Secretary to the Honorable Chief Justice? That has to be considered. But for protocol officer, it has not to be considered. How can that be, my lord?
Secretary post is already officiating. There is no.
Yes, it is also officiating, same order, my lord, same rider.
No, but in the regularization order, was the rider there?
No.
Same rider?
Nothing.
No rider.
But my lord, if you Lordship will kindly peruse that order of appointing the appellant as the secretary to the Honorable CJ as officiating, the same rider is there. He will maintain his seniority in the SJ, my lord. Same way. Ditto. So for the other order, it is relevant but for the protocol officer, it is not relevant. Had he had any grievance, he ought to come before this honorable court and get it corrected, my lord. Now, in my writ petition as an OP, he is claiming relief, my lord.
I have an answer to this.
Para 39 also, my lord. The significance of the rider is that the arrangements were absolutely temporary, where no right whatsoever was conferred upon the respondent number 5, either to continue as protocol officer to be considered for promotion to the rank of Secretary to Honorable Chief Justice. This court is fortified in being typical of the aspect of regulation of service of the respondent 5 as Secretary to the Honorable Chief Justice in view of the decisions of the Honorable Supreme Court of India laid down in Swayanto. Now, Lordship will kindly turn, what has been interfered with, my lord? Lordship will kindly turn to the next page, page 177, para 41. In view of the above, this honorable court is of the considered opinion that the impugned orders dated 10/9/2018, 10/9 is, my lord, the officiating capacity as Secretary to the Honorable Chief Justice, and 24/8/2020, that is the regularization, by which the respondent number 5 was first made the Secretary of the Honorable Chief Justice as officiating basis and subsequently regularized as such are unsustainable in law and accordingly set aside. The respondent number 5 is therefore required to be reverted back to the post of protocol officer if the High Court so desires, or to his substantive post of senior judicial assistant. To avoid causing any prejudice to the respondent number 5, it is provided that if the persons below the respondent number 5 in the gradation list are promoted to any higher post, the respondent number 5 may also be considered for the same by giving retrospective effect so far as notional benefits are concerned. Now, this is the conclusion, my lord, the impugned in this presentation. So where is the interference in the protocol officer? Where is the interference by the learned single judge in respect of protocol officer? No interference, right?
No. I think it is, yes, that's the points which suits him. Fine. Good. Because to that extent, the learned single judge is held. We are agreed by that finding of the learned single judge. And Lordship will have to decide whether this is reasonable. Simply because there is a condition rider, therefore it should be held as there is no other conclusion, nothing. Can it be so? When the law is, subtle law is that you will have to see the background nature of the post filled up, how the process of filling up the post, and in what capacity he was holding it. Question has been raised that in my officiating order as Secretary to the Honorable CJA, there is a mention that I will
Why was this rider insisted upon by the High Court?
That is, my lord, what the argument was advanced that time by the learned counsel who was appearing. That was because it was mentioned in the committee's report. So therefore it was placed there.
No, that is
there is no reason, nothing.
There was no reason given why this should have been there.
There is also nothing that this will mean that it would be a only temporary appointment, not a substantive appointment. That was also not mentioned. Therefore, now the occasion arises.
Huh? If there's a subsequent dinner filing.
My lord, probably that is, we may only think, we may only visualize that if the person who has been selected and appointed may ultimately fail to come up to the expectation of the Honorable CJ, he may have to be reverted back. At that eventuality, this rider will apply. Otherwise, that is what I
So, but subsequent to that, subsequent to the Chief Justice making that observation, it was incorporated into the rules, correct? Without revisiting that issue.
Well, I could not get your lot.
No.
Subsequently,
You see, the rider,
yeah,
that his seniority would be counted in the feeder cadre had been made on the ground that in case his performance was not up to the mark, he could be reverted back. So that was the initial reason for putting the rider.
we presume it. There is nothing mentioned.
But there has to be some reasoning.
That is what.
So assuming that supposing that is correct, but the fact remains that subsequent to that thinking that this person would be reverted back if not up to the mark, the rule, the post of secretary to HCJ was incorporated into the rules. Correct?
Well, that
Which came first? Which came first?
Who was that?
With regard to secretary.
Yes.
2003 minutes of 2003, the 18/7/2003, it was decided that if the Secretary of Chief Justice, the services of the Secretary of Chief Justice is not found satisfactory. The provision has to be there, that is to be reverted back to the original place.
So subsequent to that, I think it was
Yes,
brought into the rule. That's what I'm saying.
Subsequently, it was brought.
Subsequent to that, it was brought into the rules
Yes.
without revisiting that issue of putting this rider,
Yes.
the requirement of putting the
Yes.
rider. So it appears that there was and
This cannot be
we forgot about, the High Court forgot about that rider.
Yes. High
That-
Court, we also cannot, in my response submission, cannot presume that High Court has forgotten it. High Court has not forgotten it because that eventuality has not arisen. That he was not found unsuitable at any point of time and he was.
No,
holding
no,
the
no,
post
I'm not on
susceptible.
that. The rider had been put so that,
That this is not no more required or that.
yes, yes.
Yes.
So
That was
that should have been revisited, but
Because-
it was not.
Rightly, Madam. Lordship is right because High Court thought it that there is
Could,
no.
I'm just thinking, could that be one of the reasons why it remained
Well, my full submission.
in their support?
Well, had it been so, the authority would have decided against me that time, taking recourse to this. The subsequent incorporation in the rules. Had there been any occasion
Where
that
is the where is the decision to incorporate this post into the rules?
Secretary, Milord.
Yes,
2006, Milord, the 22/9/2006.
22/9/2006. What does the committee say
Uh, just get-
while incorporating this post into the rules?
No, rule that's.
No, into the Guwahati High Court rules.
That was not in the rules. The rider was not in the rules. That is
Huh?
what our case. The
Huh?
rider was not in the rules.
rider is not in the
That
rules.
is what I'm saying. That is what I'm saying. What
This
I'm
rider
saying is that
devoid of the rules.
what I'm saying is that the rider had been put prior to the post coming into the rules, incorporated into the rules. However, when the post was brought into the rules, the High Court forgot about the rider. That had been put in the executive.
When I was appointed, then it was after all.
Post was encadered, but rider part was left.
Rider part was left out. So if that is the case, then it goes slightly in their favor, that issue.
No, my lord, because why I say so, my lord, when this matter was, my lord, there was a detailed representation objecting the manner in which this manner of offence has been called by the association, my lord, that is the writ petition. Now that representation was placed before the committee of the honorable judges, and eventually it was forwarded to the honorable chief justice. Then, my lord, as per the record, if I am not correct, if I am not wrong, my lord, subject to correction, then the honorable chief justice wanted to know in other high courts what was the procedure followed. So, my lord, High Court of Kerala, Rajasthan, and another High Court, the modalities were, my lord, failed, my lord, wherein it was found that it was during the pleasure of the chief justice, the post of private secretary was held, and my lord, after that, option was there for reverting him back. So, based on that, my lord, this rider was
correct.
So, my lord, it cannot be obliterated, my lord, just because it is not mentioned.
No, but then you see, that was prior to this
Yes, yes.
post coming into the rules,
Prior to the encadrement.
prior to encadrement of the post. Now, once the post was encadred, then the High Court should have ensured that the rider was revisited and whether it could still justifiable, keeping in view the encadrement of the post. Now, once it has been encadred, but the High Court has forgotten about that rider,
My lord,
or still acted.
because, my lord, the condition will still persist, my lord.
How?
One chief justice, my lord, appoints, and another
No,
chief justice. So rider has to be there, my lord.
No, how can you? But once it is once the post is encadred,
My lord.
then where is the
No,
question of putting him back?
It is always on the pleasure of the chief justice. Suitability has to be assessed by the honorable chief justice. The rule says so, my lord. So if the succeeding chief justice doesn't find him suitable, then what, my lord?
But then once the post is encadred, and you have been appointed to that post, then can you be taken away or by a rider put in which is not part of the rules, in violation of the rules.
That is my case.
But my lord, appointment, in that case, if your lordships, you is correct, that has to be a substantive appointment. Only then that lordship, whatever foreign from my lordship will follow when it is a substantive appointment. Not in case of officiating or temporary. That is my humble submission before the honorable.
Anyways, but the other aspect is, for protocol officer, why was the rider put? That's another issue then. No, correct. But then divorce. But then there must have been a reason. For secretary, there was a reason. For secretary, there was a reason because if the new CJ wanted a new person, then he'd have no choice. And that would have lost meaning. Now, but for protocol officer, why was the rider put? That is, you'll have to answer that.
That is why my submission is, my lord. I have been harping upon all the time.
Huh?
As I.
No, but then you have to clarify. Okay, for secretary, supposing we agree to this, say, assuming that we agree to this view, what about the rider put in case of a protocol officer?
Well, that is why the same reason.
No, but then the protocol officer is not a discretionary thing that would serve, that protocol officer is not only to serve the Chief Justice.
No. So my argument was, let me repeat it, man. My argument is that.
I think, Mr. Bhanta, I think some other day.
This time we sincerely pray, my lord, to fix it up. If you do, can you pass out, my lord? So that in one go, lordship can finish it. We can finish it before.
I know. Problem is now this bench that I'm getting. I mean, I didn't know that.
Lordship passes an order, my lord, it can be added.
It is quite heavy. This single bench.
One day, my lord.
And it is further lingered, that heaviness will increase. Better to finish it.
Because a peace bill, my lord, will also, we are burdening your lordship by always.
Always to come back to
repeating
the
this
same
thing.
point and all.
No, but then the thing is that these are things that
Therefore.
cannot be done so fast.
I understand. Therefore, my lord, at least some clear time period is required to toss off the thing in one go, so that lordship can.
Because the law points, my lord, is not question of facts, it's all law points. That is what.
Now, since your lordship is among the top three, my lord, other administrative works are also in.
Very much. A lot of administrative work. That's the problem.
One day, my lord, if with all our sincere prayers.
Lordship may take it up any day, my lord, next week also.
No, next week he's not free. He's revising. More than that, I think this whole week, next week, everything is. I mean, we have fixed a number of cases.
Obviously.
The problem is all those batch cases have come to me. That's the problem.
November. November last week, no? November 23rd, 24th, 23rd. November 23rd. Next week, 23rd.
It's all filled up, no? We have fixed up till I think 17th or something, 16th or something. I mean, what, 15th, till 15th we have filled up everything.
December.
All hearing matters we have filled up.
So then.
Next, starting from 18 December.
18 December.
It will be motion the whole week, I think. Because that last week before vacation.
19th. Before vacation, 19th, lordship may take it up. All days, those days will be motion there.
That was Friday. And it will have the whole from 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 next week, so we are full.
You will fix by registry.
Huh?
You will fix by registry.
No, if it is fixed by registry and if lordship is not there, then how?
No, yeah, I won't. I will be here.
Hmm.
I will be. That won't be a problem. But only problem is that we have fixed so many dates already. I mean, all the hearing dates are fixed.
So the
And-
only prayer is whenever a lordship fix, let it be from the morning itself. So that-
Morning. How long will you take? From 2 o'clock?
Yes, yes.
2 o'clock, I
Yes,
think,
yes,
can be
yes.
done.
Now, we are coming nearer to it. The only thing that troubles your lordship question, we have to just.
Yes.
Only
It-
one point now.
Only that protocol of it.
Yeah.
I'm still stuck in that area.
Yeah. That I will come.
That answer we are having, just we have not yet reached that point to answer.
Oh, you have not reached.
We have not reached there. Prior to that, my lord, there are.
Because you see, protocol officer is the starting point from where everything starts.
Yes.
Though it has not been put to challenge,
Yeah.
they're basically saying is that why should we put to challenge a promotion which is not substantive? That is the case.
That is
Therefore,
the presumption and that is their
That is
projection.
why the.
That is, so you just have to, once you satisfy me on that,
Yeah.
then the rest, I mean, will fall into place.
Yes. Well, the decisions, those are already clear before a single judge and before this one have to go to clear to the, yeah. It is effective and so this cancels the.
Okay, we can,
19th, my lord, not inconvenient. 19th.
19th, I won't be here. 19th, I won't be here. I'll be here till 18th, but 19th, I don't think I'll be here.
In that case.
Because I've got to go home for some ceremony.
I see.
But the 15th, my lord.
15th is Friday, working motion day. Very difficult.
Or 14th.
And I'm telling you that 19th, all that will be a motion week.
Yeah.
18, 19, all will be a motion week.
Or 11, 12, 13, 14, 15, any day in this week. After 12. After 12, 13, 14, 15, in these 3 days, one day. my lord.
Constitution bench matter is there. Then all your reservation matters are there. Then internal matter there. Then the other matter there. They're all fixed. And a bunch matters. Not 1, 2 cases. I mean, 20, 30 cases matters.
Since lordship is now in the higher side of the hierarchy, obviously such cases will be placed before your lordship all the time. All such contentious matters.
Well, 14th, if can we try? 14th is
14th we fix.
Thursday, my lord, Thursday.
We have already fixed 2 matters, I think we have fixed.
In the second half, my lord.
We'll try our luck, my lord. 14th. From 2 p.m.
Okay, we can try. We won't fix 6 at time. I think that'll take 14th. What did we fix? We fixed 2 matters. I'm quite sure. I don't know. I think in this matter of yesterday we fixed. No? Today, the bunch matter. 83 to 96.
Then it will go to New Year, well.
Okay, we can try on 18th or no chance. But then I don't know if it will be possible for you.
On
And
18th.
for us, for me also, it won't be possible.
18th have 2, lordship will fix it, let us.
Last Monday, then. Motion day.
After motions, lordship will.
Let's do it in New Year. Let's do it in New Year.
Yes. If this was unpacked matter, lordship need not have to take up now. All this.
List the matter on, list the matter on 4th.
Not, 4th Malak, little later.
Okay.
Immediately after.
List the matter on 9 January.
Yes. Then on that, my lord, then my lord be from.
This is the matter on 9 January. Depending upon what bench I get.
Yes.
As part heard.
It's only between us. No, it's already there's a order.
My lord, mention it that it will be taken up, not at least the time frame.
Because will be taken up at 2 o'clock. At 2 o'clock.